Also, too much sound. Yes. Okay, right. Mr. Ardha, learned counsel for the petitioner, submits that the matter has become infructuous. He accordingly submits that the case can be closed. Who is appearing for the other side? Which department? 25. Mr. U. Sharma appears for the Guwahati University. In view of the submission made by the petitioner's counsel, the writ petition is closed as infructuous. Yes. Okay, right. Ms. S.B. Chaudhary, learned counsel for the petitioners, says that she may be allowed to withdraw the writ petition. Who appears for the other side? Miss P. Nayak. Have you got the name? What? How do you spell your name, madam? Naiding. Okay. Appears on behalf of the Water Resource Department. You just say Miss S.B. Chaudhary, appearing for the petitioners, says that she may be allowed to withdraw the petition as per instructions received by her from the petitioners. Then so it appears for the respondents. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn. Yes.
And I received instruction to withdraw the.
Okay, right. Mr. R. Sharma, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition as he has been given instructions from the petitioners to withdraw the writ petition. Who appears for the other side? Mr. P.K. Bora, appearing for the respondent for the Elementary Education Department, submits that he has got no comments to make. In view of the submission made by Mr. R. Sharma, the writ petition is dismissed as withdrawn.
Insofar as the 44 issues, that's a bench treatment.
Huh?
It's a bench treatment.
Bench matter, yes.
I'll play my what think of the matter. Because it inquired into bench. They had made a mention a day earlier. Before almost a short chat was given to bench treatment. Permission was granted considering the urgency. But since my work Justice Shah is not sitting today, according to the matter posted, in case what she is not taking the matter, let me what she takes up the matter.
I'm taking up all bench three matters today. I've been asked to take up bench three matters for the day. It maybe it's not mentioned here, but it was mentioned.
Yes.
26. But Mr. Banik, one thing. If you want, we can adjourn it. That's not a problem. We can adjourn it. Huh?
Otherwise, I'll be there too.
Yes. Yes, 26, yes. Why? Why? What is the problem? Huh? Second half, we'll do it in the first half. We'll do it in the first half. What is the problem? Give me item 26. You see, Mr. Counsel, you have adjourned the matter on the last two occasions. Maybe here for the petitioner.
I have 40 respondents.
Here for the respondent. No, you have also made a prayer. If for respondent number 3
Okay.
on February 2020. What is the matter about?
Regarding the start of it, assistant and master of emolumented high school. They are convinced that I am not eligible because I am from MB school. As far as the notification, MB school is I am not eligible as far as myself. But the MB school is pretty much.
There is no stay order. That is why you want adjournment. We'll take it up. You are ready. We'll take it up after this. Let the mention be finished. What is the difficult? Yeah. 20 years. Why? On what grounds? What instructions? What is the case about? Is there a stay order in your favor? Have you spoken to the other side? Have you spoken to the respondent? Just give me item number 20. With regard to marks, who is for the other side? Have you brought the records? Have you brought the records? Whatever it is. Yes, have you brought the records? Which item is this? Right. Mr. MAI Hussain, please for adjournment on the ground that he needs some clarification from the petitioner. On the other hand, Mr. U. Sharma for the Secondary Education Department seeks further time to produce the records in terms of the various orders passed by this court. When shall we list the matter on? This is the matter after 2 weeks to enable the Respondents' Council to produce the reports.
Number
19 years. Yes. No. We'll see. Whether this matter is a covered case or not. What do you mean it's not a covered case?
Actually, I am not here.
You're not here, then you tell you.
As per instruction of my senior lordship.
Where is your senior?
My senior personally lordship.
No, it has been adjourned time and again by the petitioner for no reason. It is a covered matter. It appears to be a covered matter. Where is he? In which court? He cannot come to the court. Right? Okay, right. Just give me item 19. Who appears in item 19 for the respondents? Yes, what is your stand here? Huh? What is your stand? I not your name. What is your stand in this case? What is the stand taken by the department? You've got no clue. You've got to consult who? Huh? K. Gogoi. So you are not the counsel in this case. Then why are you coming? Why are you standing? Who asked you to? Huh? Okay, you're standing in. He's in another court. No, tell him to come here. We'll wait. Okay. Next. Anyway, you give it to him. He'll fix a date.
Lordship, Article 32 and 33.
Yes.
These matters are complied with lordship.
Have it complied with? Okay, right. Mr. S. Sitradhar, learned counsel for the petitioner in 32 and petitioners in 33, submits that the order has been complied with and relief granted to the petition. Accordingly, the contempt petition can be closed. Who appears for the other side? Okay, next to it. In view of the prayer made by, in view of the submission made by Mr. S. Sutradhar, the contempt petition stands closed.
Lordship, I have another prayer in Article 27.
Yes.
Lordship. Lordship, maybe action for 2 weeks.
Why?
Lordship, they have provided with the roster sheets that we have to verify.
Okay, right. Mr. S. Sutradhar, learned counsel for the petitioner, please for 2 weeks' time to enable him to go through the roster sheets provided by the state respondents. Accordingly, this is matter for 2 weeks. For 40? Yes. Why? Then what remains? Huh? Mr. Counsel, if the order has been complied with, what remains? What records are necessary? You're for the petitioner.
Yes. No.
You're for the respondent. Order has been complied with. Yes, has the order been complied with?
Actually, in this case, the delegate is agreeing in lordship. So they have taken a consent. So the matter may come out.
Okay, right. Mr. P.J. Pugan, learned counsel for the respondent number. For both the respondents, submits that he will produce the records on 15/2/2023 to show that the order has been complied with. Okay, we will produce the compliance report on the next date. This is the matter of 52.
I beg to mention item number 28 of today's meeting.
Yes.
So the public service come after a meeting.
Here for whom?
I am for the respondent.
Have you filed the affidavit? When?
On last of the month.
When? Show me the file. Just a minute. Are we talking about the same case? Are you talking about? Then you wait your turn. You wait your turn. 1st April. Then. No, you see, one thing. In the order dated 14/12/2022, that is December, just a month back. So this PK Bora, you are PK Bora. Okay. So you did not know that you had already filed the affidavit. Okay, right.
Only thing is that my last court has directed me to whether they can be accommodated or not in any other court. That is why we have to take steps.
Okay.
So 10 days time.
Okay, right. Mr. PK Bora, Learned Counsel for the Elementary Education Department submit that he had made a wrong submission on 14/12/2022, where it has been recorded, where he has been allowed to file affidavit in opposition. He submits that affidavit in opposition has been filed by the respondent number 2 on 13/4/2022. And the Elementary Education Department is now to take a decision as to whether the petitioners can be accommodated in some other post. According to some other post, bracket non-teaching staff, right? Full stop. Accordingly, pay for 10 days. Full stop. This is the matter after 10 days.
Next week, on Friday.
What is the matter about?
Service
matter. It's a new matter.
New matter. Your lordship, they are going to be terminated. I have already taken
Is it a new case or a pending case?
No, it's a new matter.
New matter.
You have already explained.
Okay. Huh? Then it's not a new case. It's not a new case. It's a old case. Anyway, listen. Yes, Mr. Babai. It's a covered matter by the division bench. That is why you are adjourning the matter all the time. This is whether net slip is required. Then what is there? Huh? Division bench or high court. So net slip is required. Then what is there to decide? No. You take up the matter. We'll take it up at 2. You read I'll give you the second file. You have no idea. Then why did you come? Huh? Who is your senior? What item is this? 19. Give me item 19. Item 19. And they are applying for which post?
They are seeking provincialization as per 2011 or 17 Act.
To the under 2011 Act or 17 Act?
At the time of the religion control, it was under the 11 Act. They are seeking that they are engaged to be taken as a qualified criteria by exerting the latent slave. And similar to what lordship the research to people in my book and division that only negated their claims. And I would put here that latent slave the mandatory
for provincialization.
Then I would put other that the MCD complaint to distance unit.
Last chance we'll give. Last chance. Right. Adjournment prayer has been made on behalf of Mr. A.C. Borbora, Learned Senior Counsel, on the ground of personal difficulty. Mr. King Wood, Learned Counsel for the Higher Education Department, submits that the question of whether a teacher requires net/SLEP SLBT qualification for provincialization of his service has already been decided by the division bench of this court in WPC number 4788/2011.
Reported in Lordship 2017 3/56.
Comma reported in
2017 3/56.
2017
3/56.
3 He accordingly submits that the present case needs to be dismissed as it is a covered case. Next paragraph. It is noticed that the matter has been adjourned on the last court date on the prayer of Mr. A.C. Barbara, learned senior counsel. Next. Though this court is not inclined to grant adjournment, in the interest of justice, last chance is given to the petitioner's counsel to address the issue raised in this writ petition on the next day. List the matter on 9. 9 to 12.
Item 1. This matter concerns for the provincialization of services of science and mathematics teacher. Dr. Manager, please take the facts of the case.
No, what has happened? Yes.
Your Lordship, I was serving as a science and mathematics teacher, Your Lordship, against the 6th post, Your Lordship. And the Thaneswar Das Singha Takura Kochi ME school was a mixed medium school, Your Lordship. And wherein the medium of instruction wasn't.
No, tell me one thing. The district scrutiny committee has rejected your case.
Yes, Your Lordship, my name has been brought up in the list.
By the district scrutiny. Then you go to the tribunal.
Your Lordship,
Under section 14. What is that?
Your Lordship, the school has already been provincialized, Your Lordship.
So?
And as per his Act of 2017, Your Lordship, the Education Tribunal, as far as my interpretation goes, Your Lordship, deals with venture education institutions.
Correct.
The school has already been provincialized.
No, Mr. Counsel, it has to be dealt with, it has to be in connection with a venture school. You see, once a venture school is provincialized, then only the question of provincializing the services of those teachers will arise.
Yes.
You cannot have a case where the services of the teachers are provincialized and the school is still remaining as a venture school. It cannot be. It has to go hand in hand.
Yes, Your Lordship.
Then
Understand, Your Lordship, but the whole scheme of the Act relates to the very venture education institution.
correct.
But this school has already been provincialized.
Correct. So at the time of provincialization of the school,
Yes.
the provincialization of teachers was also done.
Yes, Your
Then,
Lordship.
and you were dropped.
Yes, Your Lordship.
No, you-
But my only humble submission is as regards to that, Your Lordship, since there is a provision for appellate authority to decide
You
the
go
matter.
and you apply section 14. Yes.
But I have the right under the Act of 2000.
Correct.
As per section 3(8) and 3(1)11, there has to be a science and mathematics teacher.
That you take it up as per section 14.
Yes, Your Lordship. The direction will be given.
Yes,
to the court, Your
yes.
Lordship.
Heard, Mr.
D.S. Dekha, Your Lordship.
D.S. Dekha, learned counsel for the petitioner. Who appears for the elementary education? What is your name? Mr. B.K. Bora. P. P.K. Bora. Learned counsel for the elementary education department. Mr. G. Pegu appears for respondent number 4 and Mr. S.R. Rava appears for the BDC. For respondents number 3, 5, and 6. 5, 6, and 7. Huh? 3, 5, 6, and 7. The petitioner's grievance is that though he was employed as a science and mathematics teacher in the Dhaneshwar Das Simla Takura Kuchi ME school, which was amalgamated with the Kaklabari High School district Baksa. Under the Shiksha Khetra scheme, the services of the petitioner was not provincialized. At the time of provincialization of the school, in terms of the Assam education provincialization of services of teachers and reorganization of educational institutions Act, 2017, hereinafter referred to as the 2017. The petitioner's counsel submits that in terms of section,
Your Honor, in terms of section 3.1, Roman 8 and 3.1, Roman 11, Your Honor.
3.1, 1 Roman 8 and 3.1 Roman 11 small of the 2017 Act, the services of the petitioner had to be provincialized. Next paragraph. Here, next paragraph. The counsel for the respondents, on the other hand, submit that as there is an alternative remedy available to the petitioner by way of section 14 of the 2017 Act, the petitioner should avail of the alternative remedy available. Next paragraph. On considering the fact that section 14 of the 2017 Act provides a provision for appeal against the decision made by the District Scrutiny Committee and State Level Scrutiny Committee with regard to non-provincialization of a teacher who studied in a venture school which was subsequently provincialized. This court is of the view that the petitioner should avail of the alternative remedy, statutory alternative remedy available. Accordingly, this writ petition is dismissed with liberty being given to the petition to avail of the alternative statutory remedy available with regard to his grievance under the 2017. The writ petition is accordingly dismissed. Item 2. Yes. What is that? What is this? When did you submit your application for compassion appointment? 6/6/2015 you submitted. Any representation submitted after that? Page 34. Page 34. Yes, fine. Then we'll direct that DLC should consider. If not considered earlier.
If not,
That is what we will say, that let it be placed before the DLC, provided it has not been placed and considered by the DLC. And that's all. Huh? Yes, 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 yes. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. P.K. Bora, learned counsel for the Elementary Education Department, and Mr. G. Pelu for respondent number 2 and 4. The petitioner's case is that the petitioner's father expired on, no, died in harness on 25/6/2015 while working as a provincialized assistant teacher of Balia M.E. Madrasa in the Ramakrishna Nagar Education Block, Karimganj. The petitioner thereafter submitted an application for compassionate appointment. In the when did you submit? On 6/6/2016. After the death, 1 year after the death. Actually, before 6/6/2016. The petitioner's application was forwarded by the Block Elementary Education Officer from Ramakrishna Nagar to the District Elementary Education Officer from Karimganj, while letter number RBE/2016-17/4/35 435 dated 16/6/2016. Next paragraph. The petitioner's counsel submits that despite the above facts, the district level committee (DLC) has not considered the case of the petitioner till date. He accordingly prays that a direction should be issued to the DLC to consider the petitioner's application for compassionate appointment in terms of the relevant orders of this court and guidelines issued by the state government. This paragraph. The counsels for the respondent submit that they do not have any objection to the prayer made by the petitioner's counsel, provided the DLC has not considered the petitioner's case earlier. Next paragraph. In view of the consent of the parties, the respondents are directed to place the petitioner's application for compassionate appointment before the respondent number 4 for consideration in its next meeting. The said direction is, however, subject to the petitioner's application not being decided by the DLC earlier. If the DLC has considered the petitioner's application for compassionate appointment earlier, the decision taken therein should be communicated to the petitioner. How do we know that it has not been communicated to you and they are hiding it from us? Okay, anyway. So start. They did petition accordingly this person. One thing, after their names, is it the petitioner's case is that? Okay. Yes, yes. Close. Okay. In item 1, this way close.
give direction and also consider my case for
It will have to go to whom?
you're talking the state government, the authority.
No, it will have to go to the. It will have to go to the state level scrutiny committee. Or what?
State government.
State government. So within how much some period he wants? 2 months. He wants 2 months. You want 45 days. Reverse. Okay. The appellate authority should decide the petitioner's representation, if any, appeal, representation / appeal, if any, within a period of 2 months. From the date of receipt of a certified copy, the order and the representation / appeal. It becomes, huh? 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 No. So your case is what? Your case is that he has to be promoted to Anganwadi worker, but he's not been promoted. She's not been promoted. So when was this? When was the selection done? Let us see the advertisement. Ah. No, just a minute. In page 11, which Anganwadi center are you talking about? Which serial number? Huh? Mr. Counsel, are you understanding the question put forth by this court? Are we on the same page? Do you understand what I'm saying? Which Anganwadi center, for which Anganwadi, the Anganwadi worker post is with respect to which Anganwadi center? Serial number 9. Then where is the order or document showing that you have been selected? Yes. Then, so you have not been given the you have not been posted as Anganwadi worker.
He has not been promoted.
Not been promoted, but selected.
But the thing is, here lies that difficult question of fact. Because whether or not she belongs to that area, that has to be decided by the CDPO. Now, also with regards to the private response number 5, that is also disputed because they are saying that she is not a resident of that particular sector area. And CDPO, she has been selected, private response number 5, and serial number 9, Swapna Das.
No. Swapna Das is who? This is the private respondent. Okay, has been selected. Here, petitioner has not been selected. Okay. So you have not been selected. So the question, disputed question of fact. Let it go to the director.
Yes, there are no
CDPO. CDPO. Page 19. Yes. No, you see, these issues that the CDPO look into. You go to the CDPO. We'll direct that this issue should be decided by the CDPO. This is a question of fact, Mr. Counsel. This is a writ court. We cannot take evidence. Okay. Right. Third, Mr. A.H. Alamgir, learned counsel for the petitioner. Where is it? Where is it decided? Where? Huh? What?
Advertiser was called by the CDPO. That's what we are saying.
So advertiser.
Only decided.
So let the CDPO. You see, Mr. Council, now what? Look. Please understand one question. There's not a question of arguing or having the last word. The issue is now there's a disputed question of fact whether the respondent number 5 is an outsider or not. That is your case. Now you have not been selected. Respondent number 5 has been selected. Now the question of who is an outsider will have to be decided by the authority. It's a question of fact. Number 2, have you submitted any representation to the authority? Where is your representation? Challenging the 21. Let us see to whom he has submitted. To the CDPO. So we will tell the CDPO to decide. Right. Right, Mr. Ramgir, learned counsel for the petition, who submits that the petitioner had taken part in the selection process for promotion to the post of Anganwadi worker from the post of Anganwadi helper in respect of AWC number 32 Chandrapur-1 in pursuance to the advertisement dated 23/6/2022 issued by the CDPO Lala ICDS project, Hailakandi, bracket respondent number 4. Next part. The grievance of the petitioner is that the respondent number 5, who is an outsider, has been selected for promotion as Anganwadi worker for AWC number 32 Chandrapur-1. The petitioner's counsel submits that in terms of the guidelines laid down by the submit that in terms of the guidelines laid down by the state government, the Anganwadi worker has to be a resident of the area. Has to be a resident of the same revenue village in which the Anganwadi center is located, which the respondent number 5 does not fulfill. Accordingly, submit that the respondent number 5, that the appointment of the respondent number 5 should be set aside, and the petitioner should be appointed to the said post. Next paragraph. How many candidates were there for that post? How do you know? From where do you say that 2 candidates? And how do you know that you are number 2? Are you number 2? Anyway, right. Mr. D. Bora, learned counsel appearing for the Social Welfare Department. Correspondence number 1 to 4. Submits that the question of whether the petitioner, whether the respondent number 5 is an outsider is a disputed question of fact, which can be decided by the. I don't think CDPO will be the right thing. If appointment order is by the director, Social Welfare Department.
District Social Welfare.
By the District Social Welfare Officer. By the District Social Welfare Officer of Hailakandi. in as much as the appointment order has been given by the respondent number 4. He accordingly submits that the petitioner may submit a representation to the district social welfare officer, who shall then take a decision on the same. Next para. I have heard the learned counsel for the party. The issue raised by the petition is a disputed question of fact. Secondly, whether the secondly, the issue of the number of candidates that took part in the selection process for promotion to the post of Anganwadi worker for AWC number 32 Chandrapur-1 would also have to be determined. In case the issue raised by the petitioner is decided in favor of the petitioner. In as much as the person who secures the second position in the merit list would have to be considered for the said post. In that way of the matter, the district social welfare officer Hailakandi is directed to take a decision. Is directed to examine the matter and take a decision as to whether the respondent number 5 is an outsider and pass necessary orders thereafter. So the district social welfare officer Hailakandi is accordingly is directed to take a decision on the same within a period of 2 weeks from the date of receipt of a certified copy of this order, along with a copy of the petition. The district social welfare officer Hailakandi is also implemented as respondent number 6. Oh, is respondent number 3. Okay. The writ petition is accordingly disposed. What stay? What matter? Disputed question of fact, Mr. Counsel, there's no question of state. Not on some speculation. You're speculating. We don't know. You see, there is another thing. All orders of the government, official decisions of the government are deemed to be valid as held by the Supreme Court until and unless they are cancelled, recalled, or set aside by the court. Number 4.
The great are grateful employees are for last 15-20 years without recurrence. They have approached number of times to offer this concern, putting the respondents without any question with the language. Ultimately, they approach the Honorable Chief Minister of us, which are representation. And then
what do you mean they? There's only one petitioner here. Mr. Counsel, what is this day business? There's only one petitioner here. Huh? How many petitioners are here?
The president as well as members of an association.
Oh, okay. Item 4. Item 4. Okay. Sorry.
So the Chief Minister Secretary directed the Commissioner and Secretary of Education Department to examine the matter and to place the record. Then the Commissioner and Secretary directed.
No, Mr. Counsel. First of all, who are the petitioners?
The page of number 2.
You want regularization.
Yes.
You want regularization. Now, regularization of which persons? Let them come individually. Not, there is nothing here.
They are registered.
This is not a PIL, Mr. Khan.
Registered organization can approve this or not.
Not in a, they can, but then who are those persons? Who are those persons that they're representing? Now, supposing the Guwahati High Court Bar Session members want flats, say. Guwahati High Court Bar Session, they come to the court, we require allotment of flats in that housing complex. Okay, we understand that. But then who are those persons amongst your members who are to be considered for those flats?
This one, the FX code is clear that he doesn't fit capacity.
No.
Lord, after record, we got the last meeting regarding the registration of our this question has emerged. And we look at another aspect. But the FX code is clear. If a registered organization, then the president and secretary on behalf of all the members, otherwise 5,000, 10,000, 1 lakh members will have to come.
You see, Mr. Counsel, there is another thing.
So,
There is Uma Devi's case. Uma Devi's case is there. Okay, yes. Not only that, there is ML Kesari. Section 53 has been explained. I mean, paragraph 53 has been explained. And there is the OM issued by the government of Assam with regard to regularization. Now, do they come within those three, within the authority, within the judgment, within the ambit of the judgment, and within the ambit of the office memorandum issued by the government? You explain that. You have to first explain to the court that those members who you are representing, they come within the ambit of those judgments and within the four corners of the office memorandum issued by the government of Assam. That's all. What do you do?
For the initiation of regularization process.
Mr. Counsel, first of all, you see, what does Uma Devi say?
That before regularization, a selection process must be initiated. They will have to
You see,
go through that selection
you see, as
6 months window have been.
on the date when the judgment was announced, they should have had 10 years of service. Now tell me, which of your members have 10 years of service? Give me one example. Whose names have you put? Zero. We cannot give a blanket order, everyone. It has to be. You have to be.
Initiation of regularization process.
No. You see, there is initiation of regularization process already been done by the government by way of a notification passed in 2013.
There are two aspects. One, our prayer for initiation of regularization process.
You first convince this court that your members have a right to be considered for regularization. And for that purpose, you have to show to this court that these are the members who have completed 10 years of service as on 2006.
Validity was only for 6 months window. That 10 years service with that background, only 6 months window has been given by one. Otherwise, after 2006, that was one-time exception for that 6 months. If one year are 10 years, then you will have that chance within 6 months.
Correct.
After that period, initiation of regulation process through experience. So I'm only on that aspect.
On what aspect? What aspect?
Initiation of selection process. Under the rules.
Initiation of selection. What selection process? Selection process for what?
Selection process for filling up the grade 4 post. Time taken for 15, 20, 25 years.
Okay, let us see your prayer. Please, let us see your prayer.
May I read?
To initiate appointment process to regularly fill up existing. Okay. And or to initiate regularization process.
And another aspect.
No. You see, one thing. You cannot mix up your prayers. You want to fill up vacant posts, okay. But let those individuals come whose rights have been violated. Now, if your member, if your organization is a member of working employees, Okay, you have to show who are those members, and you have got to. You can no, Mr. Khan, you cannot mix up your prayer in this manner. On one hand, you are saying that they should be regularly, grade 4 should be regularly filled up. And on the other hand, you are saying that regularization process should be started. You cannot do this. You break up your prayer, make it into two repetition. Maybe, but then I will, okay, okay. That's all. Anything else? Yes, yes, yes. These three members are they are only the head of the president of the association, president and what are they? Secretary, secretary. They don't want regularization of their service. They want. Okay, now what are they working at? Come on, just tell me if they want this petition number 1. He is not doing it for himself. He's doing it for the association member. If he's doing it for himself, should give me his particulars. No, please give me his particulars. What is his particulars? When was he appointed?
That chief minister's secretary.
I am not. You see, chief minister. You go to the chief minister. Then you have come to court. Now we see we are bound by the law, by the letters of the law.
Two from my prayers. Two from one. On the regulation. The second, the direction given by the superior authority, the director of education as well as secretary examine the records under the rules.
Show me the rules.
Rule 3 and 4.
Show me. 3 and 4 of what?
Assam secondary education provincial service rules.
Provincialization.
Yes.
Provincialization service rules.
Yes.
So you want provincialization of your services.
2003.
You want provincialization of your services.
That provincialization is also incorporated the initiation of regulation.
Actually, provincialization is a different concept from regularization. Provincialization will it's basically with regard to the venture schools. Do you mean to say that these petitioners here?
Provincialization word, but if you are also goes through the contents of the entire rule, including rule 3 and 4, may I draw your attention?
No, you see, you cannot file such a writ petition. I'm very clear. You come with those specific persons who are claiming regularization. That's a separate issue. And those who want to fill up posts, that's a separate issue. You want regular appointments to regular posts, that's a separate issue. But regularization cannot be allowed. That much I'm very clear. Unless you come within the ambit of Umadid.
I am again without placing my prayers.
Okay, I've heard.
Initiation of that selection process.
Oh, initiation selection process. In which department, in which district, in which office. You cannot have a blanket that all over state of Assam, all posts should be filled up. There's nothing there.
That is why the commissioner secretary directed the elementary education director.
You file a PIL, not here, not a writ petition. You file a PIL. That is for a PIL, not for this post. Then it's not. Then let those persons come who are really aggrieved. In this case, this petition, this petitioner number 1. What is he working as? What is he working as?
The common prayers of the entire association is that before your may I draw your attention to rule 3 and 4.
Yes.
The Assam secondary education.
So do you mean to say all the petitioners here are working under the education department?
Yes.
All under the education department. They are working as what? As grade 4.
May I read breakup? That will clarify the situation. May I read page 4? That the repetitioner humbly stated that the repetitioner number 1 is the president of Sodo Assam Vidyalaya Somapar Sotto Shreni Karmachari Sangha an association of grateful school employees of the entire Assam, registration number D so and so, then authorized to take steps on behalf of the associate association, and further, the requisition numbers 2 and 3 are its members as well as respective president and secretary of several of people in the Vidyalaya training promotion. It is stated that the requisitioners having been authorized are representing all the agreed members of the Recruitment Association in the instant case, or that the requisition numbers 1 and 3 are also agreed for non-reference of their respective services in grateful post, and or for no initiation of regulation process to fill up the existing vacant post in the entire state. Now, if your lordship comes to page 15, I won't take much time. Page 15. Type computer, translate and type.
There.
Subject to fill up vacant grade for Procedural. So, with due respect, it is to state before you honor that we are grateful employees of the schools of entire Assam. We have come to know that in the schools of Assam, there are grateful posts still lying vacant for last year about 10-15 years. And the headmasters, principals, as well as school managing committees have engaged grateful employees honorarily in some of the schools so that the schools could be run smoothly. However, presently some of the schools do not have any grateful employees at all. As such, we pray before you honor to appoint grateful employees in the existing vacancies and regularize, provincialize the associate honorary employees at the earliest. This is our humble prayer for your honor, President and Secretary of that association. Now, kindly come to page 70. The Joint Secretary to the Government of Assam Chief Minister's Secretariat. Page 70. Annex B. May I read? Page 70.
Yes, yes.
To the Commissioner and Secretary Education Department. Under order. I am directed to enclose here a copy of the letter memorandum dated 11/12/2020. I have just now read. Received from the President and Secretary Superannuation Vidyalaya Senior Promotion Sanstha, which is self-explanatory, and request you kindly to take necessary action as per the rule from your end. As per rule from your end. Now, next page, Annex C. It is dated 2nd February 2021. It is by Additional Secretary to the Government of Assam Secondary Education Department, to the Director of Secondary Education and Director of Elementary Education. Subject: forwarding of representation dated 11/12/2020. Sub: I am directed to send here a copy of the letter number so and so dated 6/12/2020 along with its enclosures, which is self-explanatory, and request you kindly to examine the representation. It is important. Finally, to examine the representation as per existing service rules in force and submit a detailed report on the matter of the government at the earliest. It was issued on 2nd February 2021 and copied to the President Secretary Shudho Assam Vidyalaya Senior Promotion. Now, my lord, no development. Now, finally, come to the rules. Assam Secondary Education Provincialization Service. Okay.
Page. Assam what? Assam what?
Assam Secondary Education Provincialization Service Rules 2003. It was amended in 2012.
Yes.
The first one. In exercise of the initial sentence. In exercise of the powers conferred by the proviso of Article 309 of the Constitution of India, the Governor of Assam is hereby pleased to make the following rules regulating the recruitment and conditions of service of the persons appointed to the Assam Secondary Education Provincialized Service, namely the arrangement of rules. Now, kindly come to is rule 3. Classes and cadres. Rule 3. Down below. Rule 3(2). The non-discharged staff in provincial schools shall consist of the following classes and cadres on the date of commencement of these rules, namely class 3, senior assistant, junior assistant. Now it is relevant. D. Class 4. Here class 4. laboratory bearer, and grade 3. Now method of recruitment. Root 4. Next. Mary. A1. Recruitment to the cadre of lower division assistant under Rule 32A2 and in class 4 post under Rule 32B. In the office of the higher secondary multi-purpose school shall be made directly by the appointing authority from the selection list prepared by the school selection committee constituted under the provisions of Rule 8C on the basis of test and interview. 2. The principal or the headmaster, as the case may, where the vacancy exists or likely to exist within the next 3 months. It is important. Vacancy exists or likely to exist within the next 3 months shall submit a proposal for filling up the said post to the inspector of schools for approval. After obtaining approval of the inspector of schools, the principal of the headmaster shall inform the district employment exchange about the vacancy with a request to send the list of candidates for selection to fill up the vacancy. It was not taken up as yet. Last 15 to 20 years. 3. Rule 4.3. After receipt of the list of candidates from district employment exchange, the principal or the headmaster shall inform the school selection committee to hold a written test for selection. Umadedi is the applicable. Lower division assistant along with typewriting test and written test along with Hagamoshi for class 4 post in consultation with the inspector of school. I am only for those 2 prayers. Initiation of regularization or selection process under the rules, and second one, the chief minister's commissioner directed the commissioner of the education department to examine their representation and to take action under the rules. Then, in turn, the commissioner directed the director of elementary education as well as secondary education to examine the matter under the rules and to place the record. For last 1 year, we are seeing kind of the entire matter. No selection, no direction for the director. So that is why this association in the representative capacity, a registered association in 89-90 has come up before your office. And it is in tune with the effects for several judgments, including money. Your lordship request I will place all the
Nothing. I find no case. I do not find any case. You come with particulars, Mr. Counsel. No particulars of the persons. How you just come that they should be regular. They should be regularly. They should be regularly filled up. Who? Why? Why should? Who are those persons who wanted to be regularly filled up? Where are they working? Where are they working as? How many persons are in your organization? How many persons in your association?
58.
58, and they are all working. Now, where are the particulars? Nothing is here. No particulars at all. No. Anyway, you have got to divide your prayer also into 2. You cannot come like this.
They will have to come just separate.
You just add their names among the list of petitioners. That's all.
It is not for
Maybe.
only for initiation of selection.
No. You see, Mr. Counsel, first of all, you have got to see their age. Now, you have, first of all, the petitioner number 1, he's 57 years of age. Can he go for a selection process as per the rules?
I admit that
You did not admit earlier.
no. There is a prayer for regulation of your services.
You see, Mr. Counsel, petitioner number 1 is 57. Petitioner number 2 is 57. Petitioner number 3 is 54.
You will have to go through the selection process and they don't have any right. They won't have any right.
Correct. So only those persons who have a right to.
But the initiation of selection process will under the rules.
Let those persons who are really aggrieved. Yes, I've heard you.
As far as the present petitioners are concerned, they already work. They are not casual workers or professional workers.
They are permanent.
There are 3 second workers. Honorary workers.
Yes, honorary workers.
There is no claim at all.
No claim, no right.
If
they want to impose ballot for a common cause, the association will have to be a party. The secretary or the president can represent it with their authorization. Here, there is not a single letter. They have come up saying that he is the president. But where is their authority? Might be one of the other members don't want this prayer. They are not a party to this kind of proceeding. Thirdly, this.
No, and where is the association? Where is the certificate? Where is the registration? Nothing is it. You make one registration, they are not a juristic person.
On both, I have indicated the registration number of 1989.
Where have you? Paragraph 2.
The third line.
Yes.
Registration number being 1995.
But who are those persons? These persons, they are all honorary members. They're not even. Where's the question of? Okay, right. Okay, right. Yeah, Mr. Counsel, just give you advice. I think you withdraw, and you divide your prayer. You throw away the prayer for regularization. You throw away the prayer for regularization, and you put those names who are honorary members of your association. Then maybe we'll consider. Otherwise, this way I cannot allow. That is this regularization. You put those persons' name at least. Why is it so difficult to put those persons' names? That these are the persons of that association. This is the particular, they have been appointed in this school on this date, and they are still working there till date. How do we know that they are working at all? Also, these are all disputed questions of fact.
Regularization word overhead the selection process.
Okay, whatever it is, you put.
I may not be selected.
Okay, right. Third. Okay. I'm just giving you advice. That's all. Because first of all, selection part, okay, we'll consider. But you put all those names. Without those names, it cannot be done. And you've got to give particulars. There's nothing here. There's nothing here to show who are your members, where are they working, what are they doing. Nothing here. We cannot do things in thin air.
If your lordship allows me, I will file additional affidavit.
No, additional affidavit will not work. Additional affidavit will not. Sorry. Heard, Mr. No. No. I'll respect all. Heard Mr. PJ Puka, learned counsel for the petitioner. Also heard Mr. B. Gogol, learned counsel for the finance department, and Mr. B. Sharma for the respondent numbers 1, 2, and 3. What are 4? 1, 3, and 4. Okay, Mr. B. What's the respondent number? Yes, I'm giving advice. You don't want to take. Okay, Mr. PJ Puka, learned counsel for the petitioner, please that he will be able to withdraw the petition with liberty to file afresh. Praise the Lord. This petition is dismissed.
Bye. Was appointed 94 as counsel. So this was regularized in the year 2004. There is a post of under the worship and page 23.
So he was regularized as Khalasi 2004.
2004.
Let us see his regularization order.
Order page 20.
Page 19. Let us see. Yes, Mr. Counsel. Yes, I've got it. His regularization is against the personal post. And the division bench has said that Personal post, ex-cadre post.
When those were vacant, higher post, junior assistant, we was set for promotion.
Maybe, but then the fact remains, they can do it. But you can, but no, the government can do it, but the court cannot do it because I am bound by the division bench judgment, which says that a person who is an ex-cadre post, who has been regularized against the post made personal to him, has got no right to promotion. So if the government wants to promote, this court has got nothing to say. However, if you want that sanctity, legal sanctity should be given with regard to your prayer for promotion, that cannot be good. Because division bench is clear. No, there's nothing. She just told me just now.
Because of page 23 and
No, maybe. As a, you see, the division bench judgment. Huh?
all the posts are there.
Right? Maybe you withdraw your writ petition and you take some you try some other method. This court cannot allow. Sorry. Division bench judgment. is-
What I think of
No, I will quote it in the order. I will quote it in the order.
2012
No, I'll quote it now.
2012
This is enough. This court will also pass enough order. Dilip Thakur, yes. That is Rishikesh. No. This is clear. Maybe we did that. I know this case has been this order has been there all along. I think you withdraw. You just try if you want. Otherwise, no point wasting court's time and everyone's time.
Let's see, because our promotional method, this promotion already saying.
Okay, right. Third, Mr. B.D. Das, then a senior counsel for the petitioner, to praise that he may be allowed to withdraw the writ petition with liberty to file fresh. Full stop. Ms. M.D. Bora, learned counsel for all the respondents submits that in terms of the judgment of the division bench in
Dilip Talukdar versus Srivastava,
Dilip Talukdar was Srivastava reported it
2012 203 155.
A person whose service has been regularized against a personal post cannot be promoted to a cadre post as the said post, as a personal post is an ex-cadre post. This time, the prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, come out with liberty as well.
I am guilty of this.
Item 6.
Just a minute. You know now what to do. How? Yes, what to do?
I'm wanted to hire it.
You worked from which year?
2006.
But then advertisement was issued.
2022.
Then
His wife appeared.
wife appeared. They did not succeed. You did not succeed. And then you have not challenged it also. You actually, in fact, you allowed your wife to appear. You see, if you have now.
Yes.
Now, how can we stop the advertisement from? That is what. So everything now, even your post is going to be filled up.
So I have not did that, but the following authority is now they have to finalize my
Can you adjust him? Son? Oh,
I know there is that the freedom of the college.
look, huh? No, but you see, the problem is the advertisement has been issued. You did not take part, your wife took part, your wife not selected. Now, how can we say that you should continue in the post? Huh?
As earlier, but I did what on 6th day of this is 5,000. Terminate my services from work and I will be at the wisdom of the college man.
They have got no legal right. The problem is they have got no legal right. Huh? No, you see, Mr. Counsel, the problem is now that is entirely up to them. What remains? What remains? Your writ petition itself has very clearly stated that you have got no right to remain. Now, what can we do? Any representation submitted by you? Huh? You have not submitted. Huh?
I submit my
You withdraw and say that you submit a representation, then we'll. Mr. N. Sharma, learned counsel for the petition, prays that he may be allowed to withdraw the writ petition, with liberty being given to the petitioner to submit a representation to the college authorities for retaining his services in some vacant posts. Huh? To some vacant posts. Mr. S. Buya appears for the correspondence number 1. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn, with liberty being provided to the petitioner to approach the college authorities with a representation with regard to his grievance. The college authorities should take a decision on the petitioner's representation within a period of 1 month from the date of receipt of the said representation, which should be accompanied with a copy of this order. You make it in the representation, make it an annexure 1.
Item 7.
Okay, we'll issue notice. Heard, Mr. I know, but then we've got to issue notice. No? Can I decide it straight away?
The direction of the letter
So it's a continuation of that. Is it? Is it a continuation of that? No, these are different process. But then the parties be there. First they straight away. Who are the parties? Okay. Who's appearing? Mr. Pegu. How can I record when you are there? You're not allowed to do this case. You just ask him. Just talk to him. Just wait. Huh? He's not allotted, so he just ask. Just tell him that this case is so. So let the concerned CGC come, and we can dispose it of as per the. Let us see your earlier judgment. Mr. Counsel, we have been dropped. Yeah, this is item number 8 of the provincialization. What is your prayer here? You want to be provincialized? Under what act? So let us see your prayer. What is this impute speaking order page? Huh? So your prayer for provincialization has been rejected by the director. Now, what to do if it's rejected by the director? Section 14. Section 14. Section 14. Won't section 14 apply? Huh? What did you say? I'm not hearing you. Huh? What? Will section 14 apply? It has to go to the secretary, to the state government.
Given me the scoping adult, otherwise finally the scoping effective one. So when they are given. So as is clear and regarding the provincial under 14
Correct. Heard, Mr. Huh? Sharma, learned counsel for the petitioner, who submits that the petitioner's prayer for provincialization has been rejected by the Director of Secondary Education by speaking order dated 28/7/2016. Then what is your prayer? That you're going to withdraw or what? Huh? Okay, next. Next para, Mr. U. Sharma, learned counsel for the
1, 2, and
respondents number 1, 2, and 3, and Mr. G. Pegu for respondent number 5.
serial number some wrong is put here. One is double mentioned. So 1, 2, 3 one.
So okay, we'll say for secondary education. Yeah, for secondary. U. Sharma appears for secondary education department, while Mr. G. Pegu appears for deputy commission for the district scrutiny committee. They submit that in terms of Section 14 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act, 2017. The decision taken by the State Level Scrutiny Committee, chaired by the Director of Secondary Education. Wait a minute. You are challenging this 2016 notification after 7 years. No, you're challenging this after 6 years, 6.5 years. But still, from 17 now, you have kept quiet for so many years. For what? Huh? Waiting for what? Then you withdraw this petition with the with the prayer to go for that section 14. Okay, that will be better. Otherwise, there's a problem of delay in that. It's too many. Heard, Mr. The petitioner's prayer for provincialization was rejected by the Director of Secondary Education by speaking on the date of 28/7/2000. He submits that in view of section 14 of the so Act, hereinafter referred to as the 2013 Act, the petitioner may file an appeal before the appropriate authority. Mr. So-and-so and Mrs. So-and-so, and submit that there were no, just say they appear for this. On the prayer of the petitioner's counsel is allowed, the writ petition is dismissed as withdrawn with liberty being given to the petitioner to file an appropriate petition under section 14 of the 2000. One minute. Yes.
And
22.
22/12/18. Respondent requirement of the case.
Your challenge what?
Thereafter,
Thereafter.
as per final procedure, election 15. That will say it is on
Page.
page 65.
Page 65.
And then index 66. Over the border.
No, maybe. What are you challenging?
Advertisement and selection process.
You're challenging the advertisement dated 2018.
Yes. And
Now-
selection process.
Now, okay, now just tell me. 2018, let us see the advertisement, which page?
And except the fish A62.
Unreadable. Anyway, what are you, which post are you, which post did you apply for?
Grade 4.
Grade 4. Which one? All the posts? All these,
Grade 4.
all the grade 4 posts? Why don't you make a typed copy of this? You can't read. Then what happened? Then you were not selected.
No, not selected.
You are not selected. The other persons have been selected.
Yes.
How many persons have been selected?
As many as 5 to 22.
5 to 22 have been selected.
Yes.
Why? Why should I? You show me what is wrong with the selection process.
Yes. There is a giving tendency of the liquidism, petition and an ITF regarding the number of candidates and answer sheets and who were selected and the marks obtained by the candidates. Again, as per reply submitted by the PIO of the respondent department, that their mark was fixed for interview 50. And as per report, respondent submitted that the extra has got 52 marks. Then next the document and procedure. Page 74.
Yes.
As per other report, B, column B,
Yes.
they have replied, you have obtained 52 marks in the written test examination and copy of answer sheet is furnished dated at the end. But in the total mark of the interview 50 marks, how the person will obtain 52?
This is for in the written test examination.
They have replied. They can know this. That's why the prisoner.
If your lordship permits to advertise that at page number 62, the whole written test was for 100 marks.
Where
At
it's so small, I can't even read it.
Yeah.
Yes, why not? Yes, Mr. Counselor, why are you not typing out a good copy? This so you cannot read. You need a magnifying glass. Even with my glasses, I can't read. Why didn't you type it out? We can't read this. Why does the court allow, the registry allow this type? Somebody they're spoiling our eyes. Yes, where?
Serial number 5, written test, heading written test.
Yes, written test. Yes.
Candidates will have to appear. I'll just read out the lordship.
Yes.
Candidates will have to appear for written test at their own expenses and when called for. The written test will be of 100 marks and will be completely overnight.
It's 100 marks. 100 marks.
And also this whole repetition is simple delay because he is selected challenging this advertisement of 2018. We are on 2023. And secondly, also the selection list is of 2019. And in terms of
And appointments made.
appointment made in 2019. Now they are rescheduling the 2023.
Already people was fighting that in the year 2019.
Maybe, but then you withdrew.
During tendency that
You withdrew.
I will kindly consider page 75. They provided target reply. 75. There is a question paper. At first column, and instruction. Number 1. There are 50 questions and each question carry for 1 mark. That means 50 questions, 1 mark, 50 marks.
Where?
How petitioner will get 52?
Where?
75 pages.
Page 75.
Instruction.
The problem is you've got 74A, 74B, or whatever. You've got 7. You see, your pagination is bad. You've got 71. From 71, it goes to 72, 73, 74B.
Yes.
Then it goes to 74. Then it goes to 74A. All haphazard. 74A should be set before 74B. But your 74B is before 74 itself.
Yes.
No. 74, then 74A, then 74B. But your pagination is 74B, then 74, then 74A. So which page did you want? 75. Yes. What does it say?
Instruction.
There are.
Serial number 1.
Ah.
There are 50 questions and each question carries 1 mark. There are lots of anomalies in the selection process.
Please explain.
Your Worship, you can page number 103.
103.
That's the OMR sheet. The answer to the petition. There are 100 questions. Maybe he has not arranged the whole question booklet.
So he's picking and choosing. Okay.
Idea.
Just a minute. Just.
For the original record, they have failed to produce.
Okay, this is regarding.
The honorable first please to direct the petitioner to file a place by stating details about it. Earlier, already advertised or selling.
This OMR is here. This is your petition. Yeah, OMR is 100 marks. There are 100 questions.
So they
Huh?
have provided.
Yes.
So they are not provided is
But he himself has marked it.
You have marked this. This is your answer sheet.
whatever they have provided, I submit to petitioner for evidence.
So what is wrong?
Respondent report is provided as per ITI information. Accordingly, submit to petitioner.
So what is- So,
They produce the original record.
so what is wrong?
They produce original record of the selection process.
No, Mr. Counsel. No, this is page 103. Is just this is the answer sheet. This is the OMR or what? QMR or what?
Yes, they have provided.
OMR. This is OMR base.
How they have got the 52 marks by the petitioner out of 50?
This is not out of 50. This is out of 100, Mr. Counsel. Please look. There are 100 questions. The 100 is written here. 1, 2, 3, 4. Just read. Please read 103.
His own signature is there.
What is
It should not be matter. As per the-
no notice? Why? You show me what is wrong. Yes, you have said your question was your allegation was you could not have been given 52 marks if there were only 50 marks, 50 questions carrying 1 mark. But this page 103 shows that there are 100 questions.
As per their instruction, they have provided this instruction. They have provided. As per page 70, 89
Correct.
and
But you
79.
see, this page 89 is in relation to page 90 to page 102, and this is 50 marks. This is a different aspect.
There are another anomaly as per page number 104.
104.
Selected publication selection process on 4/3/2019 and appointed on 5/3/2019.
What?
Page number 104.
Yes.
The order.
Yes. Order.
Appointment director order.
Huh?
With the petitioner saying. Is the office order.
Office order. Yes.
Yes. They have published the selection list on 4 and appointed in 5. An order was passed on.
Selection list on 4th.
Yes.
4th of March.
Good.
Then.
Then appointment was given on 5.
So what is wrong?
And order was passed on 6.
So what is wrong?
selection was on 4. And in immediate next day appointed. And the order of appointment was passed on 6.
Selection on 4th.
Yes.
Where is the appointment order?
This one, 104.
104 is office order, this 6 March. This is not 4.
As per this order, they appointed all this.
You said appointment order was issued on 5th. Where is the appointment order?
This is the order.
Okay, in
According to
person
them.
of the notice.
According to them, they have provided as per
This. Yes, he says selection was done on 4th. What is this?
I am also not getting.
I'm not getting it from where he's saying this.
Yes, sir. Because the order is there, this notification office order is 6 months.
6 months.
And I don't know where from.
From where are you saying that the selection was done on 4th?
They have provided as per the
Where?
This one, 104.
Where does it say 4th March? Where do you get that word 4?
The vote for is not there,
Then?
but as per their information by the petitioner.
No, information by petition will not
But it is that the appointment was 5, order was for 6.
be. It's where do you say 5?
In order to ID dated, order dated this 6 months together.
Huh? Yes, 6 March 2015. Yes. 19. Yes.
Yes. And in
In person to the notice issued by number so dated 5/3. So
yes,
what is this?
and order was in the
So this 5/3/2019 is not an appointment order. Who says it's an appointment order? Where does it say that it's an appointment order?
as per the information.
What information? Where is the information that you have?
He never selected this, those who appointed.
Okay. Only thing is that your writ petition is very thick, no doubt about it. That's all. There's nothing else.
So notice they
Why?
will come
Why
to
should-
the original record.
You first convince the court that there is something wrong with the selection process. Why should this court just issue notice just because you want notice to be issued?
There is a discrepancy, by the way.
Where? Show me the discrepancy.
Selection process.
I do not find any discrepancy.
They complete the original record.
Why should they put it? You first convince this court.
Only in the already round of these people, these honorable court has called for the record, but they have failed to put it. That's right.
No. You had withdrawn the case, Mr. Counsel. Show me where the court has said that it may have called for the record, but then nowhere.
I will check it.
No.
Today may be right.
You see out here also this last order on July 22. You would like to withdraw the instant writ petition and file a fresh petition. That's all. In fact, Mr. T.C. Chutia, the learned senior government advocate, has produced the records before this court. The records are returned. It was there, right in front of you. In fact, but then instead of though the record was there in front of you, you withdrew the writ petition.
And also the previous paragraph, the state liberty is subject to the law permitting the petitioner
To do so, yes.
That is also there. So there is a measure of delay also.
You're just playing around, trying to fish.
We are allowed to do this as private case. Now, there is a discrepancy. I will say satisfy your logic. Some document you take out to produce. Or may be given.
No. I'm not. I'm only thinking whether to dismiss or to allow your withdrawal petition. That's all.
I will withdraw. I may be allowed to withdraw private case.
No liberty. Okay, withdraw, but no liberty, because it simply just keeps on withdrawing.
How many times have you withdrawn?
Then
How many times have you withdrawn the writ petition?
you may be allowed to satisfy your.
How many times have you?
You will dissatisfied and then
We have been given enough chance by this court. I think how many times have you withdrawn? How many writ petitions have you withdrawn?
No, only one.
Only one.
Page 64 and 66 so far. I have found. 64 again, he has withdrawn.
64 you have withdrawn in 2019. In fact, I was the judge who allowed you to withdraw.
Only we done, subdivision was 392 on 31 2019. And then that's earlier. Subdivision number 81 2008 112 2019. Earlier round case of differences. It is defined as well as well. Actually, Krishna was working in the
Okay.
same department more than 12 years. Already. The respondent has been defined in this.
Your earlier writ petition dismissed.
I on there.
Appeal also dismissed.
So they were defined as
Thereafter, this also dismissed, they are withdrawn. Again filed in 22.
the respondent has been defined in this because you are saying already discharged in duty.
No case, Mr. Counsel. I allow you to withdraw. No liberty.
50 days time.
No. They have given you 4 years. 4 years time has been granted. The first withdrawal was done in 2019, second withdrawal in 22. Now, third withdrawal is a bit too much. In fact, earlier writ petition
I have to take the instruction from my dad.
no instruction is required.
At least 2 days.
Okay, we will allow you to withdraw with liberty. Yes, sir. What is it?
Again, he has approached the doctor.
What my plan will do, at least I have to take the instruction. Otherwise, you will maybe given the divorce.
Had Mr. R.C. Saikya learned counsel for the petitioner to pray that he may be allowed to withdraw the writ petition with liberty to file a fresh. Mr. A. Bora, D. Bora, learned counsel for the
For
all the respondents.
except respondent 1 to 4.
Correspondence number 1 to 4 submits that no liberty for filing afresh should be given, in as much as the petitioner has withdrawn has withdrawn 2 writ petitions on the same issue earlier, that is while order dated 23/1/2019, passed in WPC 392/2019, and while order dated 7/12/2022, passed in WPC number 812/2019. The petitioner has challenged the selection process pursuant to the advertisement dated 22/12/2018, by which the respondents number 5 to 22 have been selected and appointed. In the year 2019. The basic challenge made to the selection process is that while there were 50 questions in the written test carrying 1 mark each, the petitioner has been given 52 marks. However, instruction number, no, not instruction. However, clause 5 of the advertisement dated 22/12/2018 provides that the written test will be of 100 marks and will be completely OMR based. A perusal of page 103 shows that there were 100 questions which were OMR based and which was undertaken by the petitioner. To start, the petitioner had also signed the said document. That issue too will settle. That issue too will. Next paragraph. The above being said, the pair of the petitioner is allowed. Writ petition is dismissed as withdrawn, with liberty as paid.
Complete item number 7.
Yes. Item 7. Yes. You get it. Okay, right. Right, Mr. S. Satradhar, learned counsel for the petitioners, as well as Mr. G. Petu, learned CGC, for all the respondents. The petitioner's case is that the petitioner's case is that they had appeared in the selection process for filling up the post of constables (GD) in the Central Armed Police Forces (CAPFS). S will be small. Bracket close. A National Investigation Agency, Secretariat Security Force, and a rifleman (GD) in Assam Rifles. The examinations were held in the year 2018 in pursuance to a notice dated 21/7/2008. Next paragraph. The petitioners who belong to the SC and ST category were found to be qualified in the PET, PST and medical examination. The petitioners counsel submits that as per the mark sheets, petitioner number 1 scored 45.94207, while petitioner number 2 scored 48.35075 marks, which was higher than the mark secured by some of the unreserved category candidates. The petitioners counsel submits that the petitioners are entitled to be appointed against unreserved category posts. In terms of judgment, whatever Supreme Court judgment, you don't have. In terms of that, so dash was dash. This para. The petitioner's counsel submits that a similar matter has been disposed of by this court by order dated 18/1/2023, passed in WPC 238/2023. And according to the directions passed therein may also be passed in the present case. Next paragraph. Mr. G. Pegu, the learned counsel for the respondent, submits that he has got no objection with the prayer made by the petitioner's counsel. Next paragraph. In WPC number 238/2023, the reserve category candidates therein had also secured more marks than the last general category candidates. Not petitioners, is it petitioner? No, candidates. It should be candidate. No, just read that last sentence. Last sentence.
In the WPC 238/2023,
Ah.
the reserve category.
The reserve category candidate.
Therein had also secured more marks than the last general category candidates.
Candidate. And in that way of the matter, this court had directed the respondent authorities to verify the marks of the petitioner with the mark obtained by the last general candidate, and first of thereafter, if it was found that the reserved category candidate had obtained more marks than the last general category candidate, the reserved category candidate bracket petitioner therein bracket close was to be accommodated against the unreserved category candidate post. Unreserved category candidate post. Next. In view of the above facts, this court directs which authority? Which directs the directs the respondent number 3, 4, and 5. 3, 4, and 5 to verify the marks of the petitioner hearing with that of the marks obtained petitioner's hearing with that of the marks obtained by the unreserved category candidates who have been given appointments to the post. Pertaining to Assam, pertaining to it's not district wise, not state wise, pertaining to the state of Assam. If it is found that the if it is found that the petitioners have secured more marks than the general category candidates who have been appointed from the petitioners who have secured more marks should be accommodated by the respondent. The entire exercise should be concluded within a period of 2 months from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed. What about the Supreme Court judgment? You don't have. They give it to me. Otherwise, I have got to look for it. Mr. Das is there. He'll be nice. that unreserved category candidates that they can take over the post of the reserved general category candidate if they've got higher marks. What is that? That's
On merit,
on merit. On merit.
there cannot be a quota.
R.K. Sabharwal, na? R.K. Sabharwal. What is the citation? Citation.
1995 SC 1371. 1995 2 SCC 745.
2 SCC 745.
Para 4.
Para 4.
Application is made for employee like that. The promotion,
Item?
selection of promotion
Huh?
was taking place. The question number 7 and 8 had been counted, and this one was not counted. The promotion was made with different group. I apply a last Assam Director Minister Service, not the is the key.
What is the education qualification required
Yeah,
for?
there is a required population as per earlier rule, which is matriculation.
As per
Yes.
earlier rule.
Yes, before the amendment, there is a matriculation. And now this the rule they have applied, which is director, Assam Director Minister Service, there is a graduate. Different rule they have applied, and that's where I
Okay,
have.
you said earlier rule and now new rule.
No, earlier rule, the earlier rule of district service rule,
That has been repealed.
not repeat.
It's still there.
It's still there. Still there.
Yes, what is your case?
His case is that his appointment should be done by the earlier.
Ah.
But the rule has gone to an amendment here.
Oh, it has been amended. He just said it's not amended.
That amendment will not cover, because at the same time, junior assistant also got promoted.
Under what law? Under what law?
That earlier rule. I'm not saying, but amendment was that.
You are relying upon which judgment?
Not the-
1983.
Recently, there is a judgment.
I know. He knows. That is UU Lalit's judgment.
Hello,
Rajkumar.
but they don't want to kindly do it to the another 98.
No, you see, the problem is, I understand your case. Your case, according to you, is that as per the amendment, as per the earlier rule, when you were eligible to be considered, that rule should be applied.
Yes, because that rule now if there is applied in respect of junior assistant also.
Whatever, that rule should be applied.
Yes, yes, sir.
But then the law,
Law has a prospective effect.
No.
No, we have been appointed prior to that rule.
Huh?
We have been appointed in the grade 4 or grade 3 prior to the amendment.
you have not been appointed to now you want promotion to grade 3.
Yes, the promotion is grade 3.
Then
In respect
you have-
of promotion, in respect of promotion, in respect of senior inspector, if the requirement does not apply, then you are going to possibly examine that.
no, the law is clear.
Because of this junior assistant. Junior assistant is a higher category.
You see, the grade 4 to grade 3, earlier as per the rules, I don't know which rule it is, the graduation was not necessary. But now with the new rule, graduation is necessary. Now, your submission would have been perfectly all right if the judgment of 1983 3 SEC had not been declared to be a bad law by the
I am
Supreme.
not on that. I am not on that. Here is the case. That's why my lord, the approval of this promotion, the nation has, that as per the institution of the director of Assam director, that rule they have applied.
Okay.
They have not applied.
There, let me see.
Another page 12.
Page?
Director, page 12.
Page.
Page 12.
Yes,
The second paragraph.
yes.
That's that it may be mentioned here that as per gradation list of grade staff 1 are found qualified.
Page 12, page 12, which para?
Page 40 and it's 12.
Page, had you seen page,
41, page 40.
page 40.
40 and it's 12. They have applied their rule. That's why. Yes, sir, it may be mentioned here that as per gradation is to pay for staff, number one, so and so, then so and so, number three, so and so, are found qualified for the promotion.
No, where have they mentioned the rule? Where?
Yes, sir, yes, I am coming. As per government notification number A50 so and so, so and so, so and so, 2016. This is the amendment rule of Director of Assam.
I don't have that. As per government notification dated.
Number so and so, so and so, so and so, 2016. This is the amendment rule 12 of Director of that different government. Because
Let us see this notification.
yes, madam. This is the headed matter. I have there. You also will find page 34 type copy and endoscopy is 38.
Page 43.
Page 38 and 37. Endoscopy. Type copy is 34. Endoscopy is 38. 38 and 39. And type copy is 34 to 37. Rule 12. You will also find. In principal rules, rule 12 for assistant professor, clause 3, Roman 3, education requirement for appointment to the post of senior, a candidate must possess bachelor degree from a recognized university.
Correct. So
Yes, this rule has been applied. They have applied this rule because this rule is meant for directorate service, not for district assistant service.
Can we take up the director of establishment ministerial service, which has been amended in over 60 years?
Yes. There is your look.
page.
Page 168, 1973.
This is not applicable. This for director.
Page 168.
168.
Yes.
In the principal rule for the nomenclature of color board in the
No, page 160. Is it, Mr. Council, is it this book?
No, not this book. This book.
services.
I don't have.
Both the rules have been amended. Even this rule, your lordship services rule.
He's on a sticky wicket. So that's why we have to give him some chance.
This is on that for director staff, not for district staff.
And for district staff, what is the rule?
District assessment service for 1967.
And out there is no.
There is amendment. But because we have been prior to this enforcement of amendment. Now, nothing.
No. As per that, as per out there also is graduation
No. There is a matriculation.
for promotion.
Yes, for promotion matriculation.
But I could not get the amendment rules of 1967 here, but it is reflected in one order of the governmental code itself that is also amended.
Amended to what effect? That from grade 4 to grade 3, you need to be a graduate.
You need to be a graduate.
In that 67 rule.
67 rule.
Here also graduate.
Is to meant for.
Correct. But he's saying that even as per the other rule,
If that is so much. If that is so much. If that is so, then this should have been applied in respect of promotion of junior to senior assistant.
you see, whatever may be applied, whatever may be applied, the issue is this.
Yes, issue is whether this will affect. That's why I
No.
examine it.
No, I am asking you straight away. So can you give me the judgment? If that is recorded in the judgment, that's good enough.
Yes, sir. And in fact, WPC 9037 of 2019.
What does it say?
Either as it came from the above rules, that is rule of 1973, as well as rules from 1967, it is clear that on 28/10/2016 as well as on 15/10/2015, the rules pertaining to selection onto the post of junior assistant require the qualification to possess a degree from a recognized university.
Yes, I agree. This one I agree. Whether it is applicable to us.
You are saying 67 applies to you. That's what they're saying.
Because the department,
Okay, supposing these two rules do not apply to you. What rules will apply to you?
they don't apply in respect of function of junior and assistant to senior assistant. They don't apply.
What will apply?
Then earlier would have applied. They already promoted that. They applied the earlier. Why it is applied to me? There is a question to
Unlucky.
No.
An illegality committed earlier does not give any right to you.
No, I know. At the time, same consumer just I
Even the Assam directed establishment rules here.
Maybe
There
that.
also it's a registered cooperative society there.
Okay. What to do?
because
The ministerial rule is, I think, to appointing authority was the commissioner.
No. You see, the basic thing is that there are two rules. Now, one is the 73 rules, one is the 67 rules. Now, he's saying 67 rules will apply to him. But 67 rules also, there is an amendment of graduation. Supposing he says 73 rules does not apply, 67 rules does not apply. And my question to you is, what rules will apply to you?
here they have adopted whatever they have adopted. In respect of at the same same time,
They have promoted somebody.
the junior assistant, while promoting junior assistant, they are just matriculate. They are also matriculate. They have matriculate. They have been promoted to the senior assistant.
When?
At the same time.
When?
Same month. There is in the 22.
22. But you have not been promoted.
In respect of grade 4, for grade 3 they don't need graduation, but for grade 4 they need graduation. There is a thing, so
But then you challenge the rules, huh?
I
You see, the problem is when the rules are there, unfortunately, it is there. Whether it's right or wrong, it is there. You see, I understand it's unfair, but what to do? The rules are there. It is a valid rule unless and until it is set aside. I know your cases. If you know your case basically for promotion from grade 4 to grade 3, they need graduation. But from grade 3 to grade 2, not required. I agree. I said, have you challenged the rule?
Whatever I find, whatever there are two categories of employees. They have made by applying this recruitment.
No. You see, that is the long and short of it. I think you want to be promoted. They are insisting for graduation. You are saying that why should I be a graduate when
I have to challenge the rules.
that's what you have to
I
challenge.
have challenged those one earlier, but what I find is that two categories of employees come to the table. One prior to amendment, after amendment. After amendment, if because while making promotion, junior assistant to grade, senior assistant, they don't need graduation because they have approved junior assistant and been appointed prior to amendment of the same thing. Also, if they apply there, why not? So then I have problem. Earlier, I have also applied telling the rule I have to throw because of this. This
It's difficult. Even if you challenge, very difficult now because those persons they're all old people now, and you know what they are, so it's difficult.
I am also same year, 2009 and I.
But then what to do? The law is like that. What to do? Supreme Court has passed the law in 2022.
I have to withdraw my.
You have to withdraw.
Let's file, but they have to withdraw.
That's what I'm saying. Here is a sticky wicket. I understand your problem, but what to do? We are bound by the law.
But there is to say that the incumbent appointed prior to amendment. Because incumbent have a prior to amendment in respect of junior assistant. We are on the same footing. Prior to appointment, appointed prior to amendment. What then did not happen. After amendment only, the appointees of the incumbent I think we will do that. The date for having appointed after amendment of the rule, then only I think it is effective for that. Same thing we do for junior assistant also direct recruitment. Then it's engaged on. You only do that doesn't take good. And so two process of application transfer. That's why I not that challenging that rule I have to do.
I think you have to challenge it because if the rule is there. Because you see, YV Rangaya's case, 1983 3 years, that has said that the vacancies that occurred prior to the amended rules would have to be filled up in terms of the unamended rules. Unamended. However, this Rajkumar's case, 22.
But these vacancies
Now it has said that that is a bad law. Now what to do? No, there were 15 judgments which had gone this way. That a little bit it has digressed. But then at the end of the day, after 41 years, Supreme Court has finally said bad law. Now what to do? We are stuck. We are bound by the law. Laid down by the people. Yes, I think so. Mr. B. Sinha, learned counsel for the petitioner, says that he may be allowed to withdraw the writ petition with liberty to file an appropriate petition. Praise allowed, writ petition. And Mr. B. Raj Khoa appears for
The
Corporation Department. The affair of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as paid. Okay, writ petition is closed as withdrawn, with liberty as paid.
That's where
Here, the petitioner is a branch manager of the state of India. He has been dismissed from service.
Okay, right. Third, Ms. S. Parveen, learned counsel for the petitioner, who submits that the petitioner has been dismissed from service. Why order dated?
Where 9, 30. I'm just giving it. 18 was placed on suspension.
25/8/2020. 25/8/2020.
Yes, sir.
And office order dated 17/3/2021.
21.
2021. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondents by registered post with AD within 3 days. This is the matter after 4 weeks.
I know.
Supplementary is from Musal item 41.
Yes, what is your case?
I was initially I was appointed as another helper. I got promoted as another helper. Promotion was already CI.
Page?
Page placement. But I was again demoted to.
Demoted?
Yeah, I think demoted without citing any.
Where is the demotion order?
Please number 23. This year, and the decision of the villagers and the residents of one MLA. The local suggested that I should be removed that one because the issuer is there, she was to be putting the choice of the villagers. But luckily what happened, my lord, luckily what happened, she retired on that day. And till now the post is ready. Second paragraph, everything is mentioned. So the notification to change this is celebrated on 1 page.
Who is this Dubashri Ishwari?
One of the village worker, unemployed worker, she was supposed to reach her superannuation. At that time, the villagers demanded, we want her, so you better go. So, when the MLA suggested, she was about to be
Retired.
but luckily, on that day, she superannuated. She reached the age of 60 years.
Who?
That was Ishwari.
But she's still working.
No, she's not working.
So it's vacant.
Yeah, then what happened?
But where is the demotion? There's no demotion.
No, it is mentioned to, I was promoted.
Promoted. Then
It is mentioned on it. I will continue as an unemployed helper. It's mentioned here.
yes.
Second paragraph.
Have you this notification of February? Have you made any representation to the authorities? So we'll tell them to take a decision on your representation. I think that will be better. Otherwise, we have to ask them to update instructions. That this way you save time. Let there be a written speaking order with regard to your representation. Maybe, but then why didn't you come earlier? You see, this was of 28 February 2022. Why did you wait?
I approached.
Where? When did you approach? When did you approach?
No, verbally I approached.
Yes, verbally. We'll ask the, otherwise I'll issue notice. What do you want? We can ask them to dispose of your representation within 1 month, or we'll issue notice.
One thing is piece number 13. They issued a petition in Chirag district, and there is a few of the vacant post of Anganwadi center name is there.
Your Aganwadi, your post.
Yes, only one post is there are page 13. There are 19, serial number 19. We have it. We have legally made trying to show that it is not vacant. Then the last one.
Page.
Page 13, last page of this page.
Yes. Which one? Which serial number?
19. Last serial number. And one indicates the one post.
There is only vacancy.
Yeah, vacancy because I'm out. I get shown out.
So we say that this should not be filled up till a decision is taken.
Yes. I know that.
Right, Mr.
I didn't see it.
A Nazari learned counsel for the petitioner who submits that the petitioner was promoted from the post of Aganwadi helper, Rani Sundari AWC, to the post of honorary Aganwadi worker as per notification number SWD post of 107/2007/81 dated 4/3/2013. 4/3/2013. There is something wrong. Huh? Okay. 4/3/2013. Okay. Full stop. That's at page 20 of the repetition. However, the petitioner was not allowed to work as a Aganwadi worker, and instead was made to continue as Aganwadi helper in Rani Sundari Aganwadi Center. By notification dated 28/2/2022 issued by the CDPO, issued by the respondent number 7. Next paragraph. The petitioner's counsel submits that the post of Anganwadi worker in Rani Sundari Anganwadi Center has become vacant due to the retirement of the earlier Anganwadi worker, Srimati Dubasri, Dubasri, Iswary, page 23. This paragraph, the petitioner's counsel submits that the petitioner had submitted a representation dated 15/11/22 to the respondent number 7, praying that she be considered, that she be allowed to work as you're paid for voluntary work, sir. Not Anganwadi work. Huh? Page 24.
Under CDS.
Voluntary work, sir.
Voluntary work is appropriate.
Why? How is it appropriate?
It's mentioned in the
Paid for, as Anganwadi work. As Anganwadi.
because it's mentioned as that.
Okay, as Anganwadi work. However, the said representation has not been disposed of till date. He prays that a direction may be issued to the respondent number 7 to dispose of the petitioner's representation by a speaking order within a period of 1 month, within a specified time period. Mr. R.K. Mosahari appearing for respondent number 3 to 7. 3 to 7 and Mr. R. Dar appearing for respondents number 1 and 2. Submit that there was no objection to the prayer made by the petitioner's counsel. Next paragraph. In view of the consent of the parties, the respondent number 7 is directed to take a decision on the petitioner's representation dated 15/11/22 by way of a speaking order within a period of 1 month from the date of receipt of a certified copy of this order and a copy of the writ petition. The writ petition is disposed of accordingly. Is there any? Till a decision is taken by the respondent number 7, the advertisement dated 15/11/22 in relation to filling up of the post of Anganwadi worker against Rani Sundari AW Center, Anganwadi Center, shall not be given effect. Okay.
Item number 26.
When did we get this? What is this? Huh? I did not give you permission to upgrade. Oh, we are in the first half. Yes, yes. Yes. Oh, petitioner is not here.
I informed you.
Who has asked for adjournment?
I paid for it.
Okay, right. No one appears for the petition on call. This is the matter after the week.
Item 42.
Yes.
Thank you. What is the option? Can I directly take the page 45 of NHS 4? Petitioners have been made permanent by virtue of the legislation code. After that, non-compliance of the order. We are trying to in this content, that it is only within part of it.
Yes.
The petitioners are held entitled to continuation of service without disruption and they will be the permanent staff of the concerned veterinary council. In other words, the petitioner's service should not be dependent on the career of the vice chairman of the county. They will be treated as essential staff in the office of the vice chairman of the respective veterinary council within order acres. There were options. We have tried the content. In the content, we have found this order saying that yes, we take to record the order for the determinants and you are allowed to go. Subsequently, after going for 2 days in the office, they say already please show up. It is said to by the personal secretary, the petitioners, then the personal secretary is annoyed since we have tried to content. And subsequently, last 2-3 days, instruction was sought to be taken and then finally the affidavit is still to be taken. March, Thank you. This is also page 57. They admit that they admit that they have been shown up. In the instant method, they are ready to worship. In the instant method, the petitioner's services are as of now not required on the inside the Assam sector complex. Whenever there is such a requirement, the matter will be considered for later. This cannot be done. This would be after what kind of we are grateful employees. And they will only because of the silent consent, we have taken this grant. And now, previously we've been appointed in the secretariat, inside the secretariat. Our passes were till December 31st. Now they are not renewing their passes. They are other offices. They will be given chances in other offices. My lord. What now, my lord, my friend is trying to do is, my lord, he is trying to tinker with the division from judgment. I will take you, my lord, to the next petition. Page number 37.
37.
37. There is the order of the court, para 17. This is the directive part. Page 37.
Yes.
Para 17.
Yes.
Following the above.
Yes. Yes.
Following the above, the petitioners are held entitled to continuation of service without disruption, and they be treated as permanent staff of the concerned advisory council.
Yes.
Concerned advisory council. In other words, the petitioner's service should not be dependent on the tenure of the vice chairman, vice chairman of the council, and they will be treated as essential staff in the office of the vice chairman of the respective advisory council. It is ordered accordingly. So, my lord, the direction of the division bench was to treat them as permanent staff of advisory council, my lord. Advisory council of the vice chairman.
That is single bench judgment.
That has been appealed by against division bench.
Okay, division bench.
This is not
Page 43. Okay.
Down below. There is a single judge. As we review assessment. 44 is the pilot, 44 is the operating partner. The reason is 44 division bench. The reasoning given by the learned single judge was that both the appointment of chairman and vice chairman of this advisory council may be political appointment, but the post held by the supporting staff are permanent in nature. Therefore, they are being in service only till the time when such chairman and vice chairman is holding the post. He is not just as fair. It is for this reason that the direction was issued to the respondent to treat them as permanent staff of the council. My lord, everywhere it is council. Now, my lord, coming back to the text. My lord,
my lord is clear about this direction of honorable single judge in the division bench, my lord. They are to be treated as a permanent staff of the council of, that is vice chairman and chairman. Now, my lord, coming back to the content. They filed a contempt matter in this. Then, my lord, in page 45, we will find their writ petition matter, page 45. In the first paragraph, we have quoted the division of judgment matter, and then in the third paragraph, that is the order first. In pursuance to the order dated 25/5/17. Page number 45 of the writ petition.
Yes.
Page number 40 of the writ petition, my lord. That is the order that passed by the department, my lord. First paragraph is the observation of the Honorable High Court, my lord, the order. The third paragraph is the, my lord, the trust. In pursuance to the order dated 25/5/17, in writ petition number certain, sir, it is directed that the petitioner service will be continued without disruption, and they will be treated as a permanent staff of the concerned advisory council. That is, their service will not be dependent on the tenure of the vice chairman of the council, and they will be treated as permanent staff of the vice chairman of respective councils. This order is filed in compliance of the order. That is our order. Now, my lord, I am coming back to their now. I don't know what they are trying to do is now. These are called political posts. When there is a chairman, they will go to the office. This particular MLA, they become the chairman, and they decide where the office will be. For the last 5 years, there is no office. There is no chairman. But since the effect of this Honorable High Court order, they will be getting the salary. They will remain as the staff of the council. Now, what they want to do, they want to get into the department. They want to sit in the office of the principal secretary. That is not the order of the court. That is what we have said in our affidavit. We have nothing. When there will be.
No, you see, I think you have got to challenge the judgments in the Supreme Court.
No, we have come back. We have come back, madam. Don't say that of the chairman. We said yes, they will. But now they're trying to circumvent it. They said that we will go and sit in the office of the principal secretary. That is not the order of the court, my lord. That is a separate entity.
No, you see, they are the staff of the council. It is not that the staff of the chairman or something. They are staff of the council. That's all.
That is what, my lord. They are staff of the council. They will go to the council office, not in the office of the, my lord, principal secretary.
Okay.
My lord, that is our.
So let them go to the council office.
Exactly, that is what we say. But they cannot come to the. They cannot become a member of this. My lord, there is no required. My lord, there is no council. So, but they will be getting.
No, maybe there are no council members, but the council will be.
No, council, my lord, council, there is no office.
Only there is no office. It has to be there.
The chairman decides, my lord, where the office will be.
No. You cannot do that. That is wrong, Mr. Counsel. You cannot do that. Actually, you see, they are coterminous staff, no doubt. A lot of coterminous is there. Even as judges, sometimes we have got this MR coterminous. And but since now order has been passed by the court and they have been complied with it, that they will become permanent staff. They will become permanent staff.
Permanent from the council, not of the department. Council is also different entity value.
Can you differentiate between the judges and the High Court?
For an instance, for an argument, I'm making argument now. I will bear with me. My lord, taking instance of a foreigner tribunal. We have so many foreign tribunals in the state. Now, suppose the court tells that this the support staff of the foreign tribunal will become permanent staff. Whether that member is there or not. It's council member. Suppose ballot,
Why not?
look, there I'm coming back. So tomorrow, 5 member goes off. It's called off my lord. Now whether they will come back since that notification was by the direction of the High Court was passed by Home Department. Whether they go to Home Department now, my lord?
We have to take them.
No, where will take them?
You put them in the council office, you make them, you, whatever.
There is
If
no,
there's no member,
that is what my lord counts. There
if,
is no council.
if the, you see,
From 2017, there is no council of it.
no, Mr. Council, one thing. This council it's under the 6th schedule.
No, not
Under what?
actually. These are my lord advisory council, they advise my the political post.
Okay, political code. So is that entire council done away with? Has it been done away with by the state government? Has it been made defunct? Then that's a different issue. Otherwise, if they are still there and just because the chairman or something is not there, doesn't mean that it's not there.
These councils are formed after every election. After 2017, no such council has been formed.
Maybe.
So from 2017, there is no chairman or vice chairman, but they are treated as my lord by the in compliance of this honorable High Court order. They are treated as member of the council. But my lord, what they are trying to do is they want to get into the office of the principal secretary. That is what my lord, they are not employees of the government.
Why don't you challenge the judgment?
That is what I have advised.
At the end of the day, it boils down to that.
My lord, but they cannot be attached to the office of the WPT department. That is
May not be attached to any department, but they'll be attached to the council. Let them get their pay. They want their pay.
that is what we are saying.
They want to watch TV, Netflix. You just give them pay for the thing if you have got no work in the office. No, you have made them permanent. You have got to give them pay. And you have got to give them work. If you don't give them work, that's a different issue.
That is what we said, my lord, in our affidavit in the parasis. Maybe parasis.
Otherwise, what to do with this matter? No, you have got to consider what to do with this. You cannot. Last 1 week. No, heavens will not fall.
They are getting their service. That is what we said. Suppose they will.
Okay, you obtain instructions of how you accommodate them.
No, accommodation is my lord. We have to go by decision with them. They are the member of the advisory council.
That argument will not. All right. Mr. K. Manta appears for the petitioners, while Mr. Ardhar appears for the respondent number 1. Mr. Pegu, are you there? No. Okay, right. List the matter again on Wednesday. Thursday. The matter of also. Then Mr. Ardhar shall obtain instructions as to whether why they have not been allowed to work and whether they can be accommodated.
No, we cannot matter.
Accommodated in the council's office.
Council office, my lord. Council office, that is what we are saying. That is what council office.
Comma, even in the absence of the chairman.
That is what we are saying.
You have to. Even in the absence. There's no escape, Mr.
No. My lord, we have no issue for them to go into council office, but we cannot let them.
You let them, if you're willing to make them sit put 2 plastic chairs or 3 plastic chairs. That's enough. And give them their monthly pay.
My lord,
And number 1. At page 75, the gradation list, which comes up in the website on 11/1/2002.
Yes.
where I'm all along been shown as number one.
What is your name? Yeah, Prabir Chandra Katakati.
I am Mr. Pradeep Chandra Kakati.
Yes.
One of the funny part of the thing is that the combined list, the civil service.
This is a seniority list of what?
Cadre of secretary. I'm the cadre of secretary.
Secretary.
Secretary, I am holding the post of cadre of secretary. There are 30 posts in the cadre. Logic will find that the gradation list in terms of the rules has to be cadre wise. Logic is similar because I have done some similar cases. The rules are in place.
Pages are inconsistent. He is referring to a gradation is 75.
I have been able to give a discipline. He is from the WPPD department after I complete.
No, he is saying that he's 75 and your 75 doesn't match.
And moreover, he is representing the WPD department which is supporting my case. The rules in place, logic knows that the selection grade, the senior,
So if he's supporting your case,
yes.
you have to be more civil to him.
No,
And in fact, more accommodating towards him. Otherwise, you are going to make an otherwise you are going to make an enemy out of a friend.
No, I don't need the enemy. Because if the board is with me, I need not worry about
No.
the board is with
I just said that the thing doesn't take away. Just sit
Let
down.
us not make an issue. Please, my friend, please, this sort of stuff comes up.
Well. Anyway.
At the end of the day, we are friends. That is the beauty of the judicial process. No, your logic will come to.
No, just a minute. Take a deep breath.
Yes.
You're in a hurry. You're in a hurry. Take a deep breath. Let's
Yes.
be cool about it. Okay, so we have I've got the rules. Whatever.
Logic will come to the rule 23.
23.
Yes. This is, I'm the senior most in the cadre of civil service, gradation list, rule 23. Can I read it out?
Yes.
There shall be prepared and published every year a gradation list containing the names of all the members of the service cadre-wise in order of seniority and such other particulars as the date of birth, date of appointment. The lordship will come to page 75. In the 75 at column 1, Praveer Kakati,
Yes.
my date of birth is given,
Yes.
my caste is given,
Yes.
my grade is given,
Ah.
and my batch is given, and my posting is given, but there is no mention of cadre. This is the first flaw because the entire genesis of my problem is this. So, then your lordship will come. Your lordship will find that in the gradation list, the entire gradation list, in the civil service, there are 900 officers. The lordship will find 76 space 76. The last line is 920. So that entire backbone of the Assam administration of the civil service. From there they go to the all India service. 920.
920 is entire
Yes, entire list.
of officials in Assam.
Not cadre wise. What wise I don't have. So in my entire
It is for all departments. It cannot be.
No, they are not departments. The cadre of there are
Different
commission of posts. There are 30 cadre posts of secretary. There are other posts which additional secretary, joint secretary, DC and all. But this is something very serious because for the first time a gradation list is coming up in the website where I come to know, Lordship, that it is not cadre wise in terms of the rules I have already shown. Your Lordship will come to page 77. This is an order of the government under personnel department, dated 30th January 2023.
Yes.
Lordship, 23. Your Lordship will find 3 officers were promoted to the rank of commissioner. Your Lordship, in the interest of public service, Kamal Kumar Bushro, secretary to the government of Assam, such and such is allowed to officiate in the rank of commissioner and secretary, ACS cadre to the government of Assam on the scale of such and such. Secondly, your Lordship will find Sri Farooq Alam, again he is posted as commissioner and secretary, so they are promoted. Dhruva Das. Now then your lordship will come to page 75. And your lordship come to page 75.
Just a minute. ACS. Page 70.
5. Lordship will find at page 75 again, serial 1 is Pradesh Kakati. Number 2 is Nampuri. Number 3 is Kamal Kumar Bhattacharya, which is the promotion order. The Farooq Alam is also there in the 28th January's promotion order. Dhruva Das. Hello? The promotion orders are issued to them, oblivious of the fact that the rules envisage that it's a selection course. I don't get the reasons as to why I was brought down. So immediately
Brought down meaning?
to the I'm already in a supersede me. And at para 17, this is the most serious part. I take specific averment to the fact because I never emphasized that the gradation rules will be in terms of the rules. At page 17, para the lordship, page 32, the lordship will come. I made a specific averment, which I will read. The petition of can I read?
Just a minute.
Page 30.
Yes.
The petitioner begs to state that on the other hand, on 11/1/2003, 23, sorry, the final petition list of cadres of secretary, additional secretaries under the Assam Civil Service Department for the year was published where the names of the petitioner was based at serial 1. In a cadre strength of 13, the promotion to the next higher cadre of the commissioner secretary had cadre strength of 3. The promotee respondent named Dhruva Das is superannuated, has already superannuated on 1st of February, thereby creating a resultant vacancy in the post of commissioner secretary. The petitioner needs to be filled up by the petitioner as he is within the zone of consideration. Then I skip this part. So my contention is that a selection.
You should be considered, not.
Yes, yes. And the selection is done, I don't know. I would say never give. Now the new trend, because logic knows a new thing has happened. The award part of judgment has been overruled by the court. And possibly the first time in this country.
No, this is basically this is selection post.
Yes, it's a selection post, but basically my contention is that in violation of the rules, the rule 34, the gradation list was never prepared, and they did not do it otherwise. As a result, these persons come up. I don't know the.
You are in which cadre
I'm
otherwise?
in the cadre of secretary.
No, cadre or secretary, but how many cadres are there? Tell me your cadre what?
The cadre which is relevant for me, I can get. Because I've already got promoted from down below. I came from EC, joint secretary, additional secretary, and secretary. In fact, I got promotion in the year 2020. So my contention at this stage is very simple because another fact is there. I'm also eligible for the All India service and the Guwahati High Court. In fact, my ACRs were downgraded and I moved the Guwahati High Court and they have kept one post for me in the cadre for the All India service. Now, this thing happening is affecting me because I'm the same cadre now. So my prayer is that if the resulting vacancy of Mr. Das is filled up, I lose out because already there is an interim order which protects me in the All India service.
That is a different issue.
Yes. So at this moment, what I want, the lordship will call for the records, the minors may be given, and in the meantime, without leave of the court, one post may be kept vacant because on similar cases, the lordship had already passed orders, 2 orders in the same similar in Deepego and Vikas family case, the lordship had same issue, same contention in violation of the rules. They bring me down and your lordship protected. So that is my case. Lordship will take up 2 orders, WPC 6340 and 63. When same issues I was brought down, and in fact now the division bench of the Guwahati High Court has.
No, this is a different issue.
This was an issue where the gradation list where rules were very specific. it has to be cadre wise. This was not given, I came down. And in the end, your lordship's protection helped me because Body High Court gave it in my favor. But the government now has not implemented. I moved the division bench content, and content proceeding has been drawn up by the division bench. So I think that the records be called for because nothing has to do with the rules. Because they never made it cadre wise, and one post may be made cadre.
This is a different issue.
But it was downgraded, same issue. Because
Where is
was
it downgraded?
The new OM came in whereby the judgment of one part was overruled, that is under challenge. I have annexed it. And the single bench, seeing the seriousness, said that now all promotion will be. No, I have one reiterate. But I didn't want to because no court will give an OM, stay in OM on the first day. I know my limitation. As a lawyer, I can always pay. But all promotion has been made provisional for a simple reason. The lordship has said, indicated that this is a very important issue raised now. Because I have raised the issue regarding overruling of the judgment by an OM. So here I am concerned with statutory violation, which they could not show, they not to show. Because the otherwise it was not, and I wish to know
praying for a notice of motion, will respond.
When
I'm objecting.
will you respond? When will you respond?
No, my lord, because the money rules has to be there because they hold the selection.
But supposing he superseded,
That's my inquiry.
supposing he is superseded, then what happens?
My lord can always
Difficult, you know how.
undo by.
No, I will not pay for one.
You see, we can give 3 weeks, but then there will be a stay,
Okay, my lord.
not to fill up the post. Otherwise, you obtain instructions. Today's the what?
Next Thursday, my lord. My lord, I have come down to 4 days from 3 weeks. No stay, my lord. Thursday.
Thursday.
Yes. I will bring the record to you. Because next week I will not bring the
They
record.
will not proceed without the name of the court because I have seen what they did in my earlier case. They allow the person to join. Well, brazeness is there. I did not see much. And after that, since they take the plea that he has said it will be subject to that. And the precipitative action, the courts are there to prevent. Not if I say let them take time, like I wanted protection. That's fine. Because now I lose out. Because we want emphasis, the officers, we are senior most officers, we want that it should be conforming to the rules. But these are everything. They ask me, Mr. Dar, what's the point of having rules? I have to go to the court for the simple reason the rules. They don't make the gradation list system. That's my case. It's a very serious case. That's it. And ultimately, the records, if I find out.
You're taking up all the oxygen. Let him also breathe.
There's less oxygen.
I will issue notice, my lord. We will file an affidavit. I'm ready to regarding protection, my lord. I'm ready to.
Very fair.
Because without instructions, my lord, even I can protect that.
So what we can do is,
My lord.
there are 2 aspects.
My lord.
Either we issue notice and then you file affidavit, or next week you bring the record, but still there will be protection till the next day. Either way.
If my lord is giving protection to them, my lord is no point, my lord.
No, but because you see, the thing is that then at least the matter can be disposed of expeditiously. Yes.
Then my lord, then we need some time again. If there is a protection, my lord, we need time to file an affidavit, my lord.
Okay, right. Heard Mr. D.K. Das, Learned Counsel for the petition.
Sir, what is making
Heard Mr. D.K. Das, Learned Counsel for the petition. Also heard Mr. R. Dhar, Learned Counsel for the all respondent numbers.
My lord, I will appear for 1, 2, 3, 4, 5, up to 5, my lord. As an additional senior government.
Additional senior government. The petitioner what is this office memorandum that they're challenging?
This, because the government of Assam in the meantime came up with an OM, but that doesn't hit me for this information. I am protected by RKS Suburban because in the selection post, as I go up, I go as a member of the unreserved.
No, but then in that case, then why did you make a challenge to set
So I
aside?
have to make because in the selection when the hearing takes place, they will take up the plea. So similar cases I have done.
They will take up a plea that what?
They
That
will take up the plea that the 18 OM has come over, but I can take up the plea that the 18 OM has over. And that's something petitioner can take because I have challenged the constitution. And for notice.
let us see this OM of 23.
Yes,
where
yes,
the-
Lordship. Your Lordship will come to page 139. And in fact, I am affected by clause 4A, last subpara. Because they have overruled RKS Suburban. If I may read, Lordship.
Yes.
If any occasion arises during the promotion process in the grade A class in which stipulated percentage in respect of reserve is met in the next promotional grade, but in the zone of consideration there are candidates of reserve who on merit are entitled to the promotion, their case shall be considered for promotion on merit if such candidates are not made into zone by way of any accelerated promotion only. That bar is there. So that bar was struck down. A specific case I made was struck down in the Bhagwan Pater's case. Now the government has overruled it. That is my case, and considering my case, the learned sitting judge about a week back says this matter needs examination. So we are issuing notice and we are getting all promotion of the. No, I'm not an independent. I'm not an independent because I know I have the confidence this OM will also meet the same fate as Bhagwan Pater.
No, but then if there is this OM, then how can we just give a stay straight away?
No, I'm not. What I'm saying that they will not fill up the role. Let the minors come. I'm ready for hearing next week only. I'm totally ready, because he has been very fair. When he says that we'll bring the record and expedition.
So you said 4 days. You said 4 days. 4 days, then Tuesday. 4 days is Tuesday.
No.
And then hearing will be
Working is done.
Huh?
Working is done. I don't see today is Friday. By the time I fix my chamber, I have to write letter. 7 o'clock. Tomorrow is for Sunday. Monday only that letter will go. Once the letter goes, and once you practically are telling her, now the officers in Assam are everybody is busy in this. Not so.
G20.
Everybody matter. Wherever I go, they are posted somewhere.
And for G20, I cannot use my summary.
That is the problem. And that is why on the calculation I have asked for 4 days. So I have calculated the people.
What about that fate or something that's going over on the Brahmaputra?
But I think they have wound up because you never know once the rain comes that I know.
No. Yesterday also there was a lot of music coming from there. I was thinking from where is this music coming? I was thinking.
Oh, that is Sky Festival.
Huh?
Yes.
Kite.
Kite
No. It's in the island. It's in the river.
Yeah. Brahmaputra Carnival.
How do we go and participate there? Boat. Or we swim.
No, they have
Ferry. Weekend is coming up, so I thought.
That is why I need some time in person. Everybody, police officers, all departments, they are all deputed, different. Because it's a matter of nation's matter of pride.
Can you give an undertaking that you will not fill up till Thursday?
I'm giving an undertaking.
Oh, you're giving an undertaking. Okay. If you're giving an undertaking, then you give an undertaking, then will not be filled up. Then I will not give a stay order. Status quo order. I will not give a status quo. Not to fill up. Otherwise, everything will be delayed.
principally like that. If anything happens in the marriage, you always undo. I have understood
No, no, no,
actual law.
no. You know it cannot be done. You know.
I want to protect the grant of the high court.
No, no. You see, because this issue was there yesterday also. Today is the third, fourth. What is it?
Yes.
Third, the third.
It was fixed for interim order. Yesterday notices were issued also.
No notice. Huh?
No, madam. Yesterday they came and they would have taken a copy.
Yes, no copy was given. Yes.
Exactly, madam. And there also they have taken your wrong book. That's what I brought to give you a wrong.
They give you the wrong?
This pages, madam, all in different pages.
Ah,
That's not-
you
now
think
I-
of it.
Right now only I got this copy in the
Right,
court.
right. Heard Mr. D.K. Das, the counsel for the petitioner, who submits that the gradation list that the gradation is dated 11/1/2023, in which the petitioner is placed at serial number 1, has not been made in terms of Rule 23
Yes.
of the Assam Civil Service Rules 1998, in as much as the service cadre of the persons in the gradation list have not been mentioned. It further submits.
You have made otherwise.
Huh?
Made otherwise.
Have not been made cadre-wise. Have not been made cadre-wise. No, have not been made cadre-wise. It further submits that the persons who are at serial number
3, 4, and 5.
3, 4, and 5 had been promoted to the rank of Commissioner Secretary to the Government of Assam by notification dated 30/01/2023, without considering the case of the petition. They must have considered it without considering the case of the petition. He further submits that as Dhruva Jyoti Das has gone on superannuation pension on first, cannot be first, has to be 31st January,
Yes, petition.
31/1,
First, the vacancy.
31/1/2023. The said post, the said vacant post, earlier occupied by Dhruva Jyoti Das, should not be filled up till final disposal of the fee. Next para. Mr. Ardhar, no, issue notice, no, Mr. Ardhar, then counsel for the. Yes. For respondent number 1 to 5.
1 to 5 minutes.
1 to 5. Submits that he will produce the records on the. He'll produce the records on 9 this Thursday. Thursday, 9/2/2023. Accordingly, this will matter on 9/2/2023. But what about the private respondents? Then we have to issue notice prior to that. Then issue notice returnable in 1 week. Petitioner to take steps for service of notice upon the respondents, private respondents by registered post issued within the course of the day.
Tomorrow.
It is tomorrow holiday or working day? Within 2 days. Within 2 days. So in addition to the above, the petitioner shall take steps for service of notice upon the private respondents through dusty service and file the affidavit of service by 8/2/2020. This is the matter of service. Till the next date. Till the next date, the respondents are directed not to fill up the post vacated by the respondent number 8. Why is he still a party? Why is he made a party? If he's
No, as a department, because ultimately, even if we don't take.
vacated by the respondent number 8. Respondent number 8 on superannuation. Okay.
6 and 7 will be.
Okay. You should notice only to respondents number 1 to 7. 1 to 7. Right, huh? Then you just say 1 to 7.
All right. So my notice. Yeah, I have to respond by within.
That is there also.
In 3 days, how can I?
Okay, you just say, don't issue notice. Cut the notice, just say the other things. Huh? That's it. No, actually not required also. They're already promoted. So they doesn't.
Action on the resulting vacancy remains.
That's what it is.
Alright, he's already not taken there. I don't know by the time we are arguing.
That is a different matter. That is different.
Is he trying to say that by the time we are arguing, they will fill up? Then you are watching.
No, if it happens, it happens. Okay, that's
Alright. Item 44.
yes.
Under the airport, yes. The two colors, basically. So the exterior color and non-exterior.
Okay. Executive cadre will be the officers
Officers.
and non-executive cadre.
Technical portions.
Technical. What about all those grade 4 and those pure non-executive?
In the non-executive, the levels 1 to 10.
In the non-executive.
The levels 1 to 10. As we move up, we are concerned with NE6, non-executive level 6, level 6. That is for secret assistant operations.
Senior assistant operation.
Operations. As you launching when you say airport, launching facility lounge or judges. This gentleman in operations will take care of it. For instance, all launching is going to the like something is happening. There's storm out there. He has to drive and rush in the storm in a production. Suppose there's a storm out there, the flight is down. So protection will be given to passengers. So the person who would drive the vehicles to the flight would be one of the operations. Therefore, LLB certificate license is required for that person. Now,
What license is required? LMB.
LLB. Now, the authorities issue a circular at page 20. For filling amongst others, this was filing number.
Where is it? Yes.
Page 20. May I? In accordance with the permissions of so-and-so, it is proposed to pick up the following vacancies of senior assistants every 6th level in the pay scale of so-and-so. So departmental examinations of Northeastern region. I'm concerned with senior assistant operations. Right. Now, the second of the grade below would say the education qualification. That is the first one. Graduate with LLB license, diploma in management will be preferred. First, education or experience, 2 years relevant experience in the consultancy. So my name is Azimuddin Khan and I all the requirements. Applicant provision of facts are, under permission from the authorities, I have completed my graduation, my diploma in hotel management, and I have a license which is in operation, will be until the years for period. No, I apply. But once having met the requirements under the circular, the only thing is that I apply to shortlist. So I take things pending. And eventually I got the result. First time in October, 1st of October. Can we consider my case? Yes, I am coming, they did not respond.
Last year.
They did not respond. But once they did not respond, I come to know that few days back, they actually held the examination.
Few days prior to your letter.
Prior to my letter. So I again continued. Can I say that? I kindly consider my case. It's only a consideration. I'm not getting a thing. Promotion. I need the requirements. They did not respond. Eventually, I sent a previous notice. They did not respond to that. By the time I come to know that 2 persons were shortlisted of the 5.
Of the five posts.
Of 5 posts, 2 were shortlisted. At page 44. This I can come to learn much later. Page 44. In reviewing all documents of the applications was my work evidence about page 44. With reference to office circular 32202, which is also uploaded into the website to ensure the wide circulation regarding filling of the vacancies in the grade of senior assistant any 600 posts in various disciplines to department examination in the MEA. In this connection, it is to implement the following candidates have been found eligible and are shortlisted to appear for computer-based test. Details of which are communicated in due course of time. So they will be generated. These I could come to them very easily. But they are typing. What are representations? They don't even tell me that you will reject every from how they challenge that. I keep on communicating with them. They keep it. They have the problem. Once I get it, I technically do not challenge their shortlisting because it's a 5-week number. It's still freedom. Now I am on the instruction to submit before my lord that till date they have not filled up any of these posts. And perhaps out of 2, 1 has been shortlisted for the promotion. I do not know. But anyways, I give it up to. We have respondents in the requisition. Present documents are there as an annex of the requisition. Which would demonstratively show that I meet the qualifications and requirements. Plus, there are certificates of appreciation etc. by the authorities, the director of the airport.
So what do you want?
My lord, they will consider my case and not fill up the post. How do I go otherwise? I have nowhere to go. By the record, I am submitting that I feel.
So your case is that you were not considered or were you considered?
I was not considered. Now, in the wake of this document, it appears rejected. No communication, nothing. On the face of it, nothing. I keep on communicating with them. Page 38, 40, all the my communications.
Yes.
See, I need to have my instructions, but page 44, it will not.
Yes. Yes.
My friend is referring to the 2 persons.
Yes, yes.
You will see in this following 2 candidates have been found eligible.
Ah.
Similar, when we,
And are shortlisted.
yes, that means petitioner perhaps has not. Because these are the
Correct.
only, because many of
So you
them
apply
will-
instruction?
So I'll have my
In the
instructions.
meantime, one post may not be
No, there are 5
There are
posts.
five
There are
posts.
5 posts. There are only 2 persons who are
Already
shortlisted.
we are not
Where
getting
is-
candidates, man.
Yes, where is the question?
the other thing they come in the way, which if I submit the next day, I can show for them. But in the meantime, the process is over. And we close it up there.
No, so what we can do is we can keep a short date for him to consider to bring his issue notice.
In the meantime, we are not close the section.
No, let us see. We do not know.
My lordships, I will invite your attention to documents which I have for qualification. At least that is to my satisfaction.
You see, your satisfaction more than that is the court satisfaction in this. Right.
When they require the documents, I have the documents by qualification. They leave me out for no reason. I seek for a reason, they don't answer for.
Let us see. Heard Mr. S. Bani, learned counsel for the petitioner.
Our lordship would give it for motion.
No.
See for motion. Then you have
Everything giving for motion is a problem. Heard Mr. S. Bani, learned counsel for the petitioner. to submit that the petitioner had submitted his application for filling up 5 vacant posts of
Senior system operations.
huh?
Senior system.
Senior assistant operations in pursuance to the advertisement dated 3/2/22. The petitioner's further case is that as he was not being given any intimation with regard to the selection process for filling up the said vacancies, the petitioner wrote a letter on 1/10/22 to the authorities. Thereafter, further communication was made and even a pleader's notice was sent to the authorities requesting them to call the petitioner for appearing in the test for filling up the vacancies. The petitioner's counsel submit that the petitioner came to learn that the respondent authorities had shortlisted 2 candidates for the post of senior assistant operations, some of which did not include the petitioner, by letter dated 30/08/22 issued by the Airports Authority of India, AAI. The petitioner's counsel, next one, the petitioner's counsel submits that a direction should be issued to the respondent to consider the case of the petitioner for appointment to the vacancies, even though the said letter dated 30/08/22 implies that the petitioner's candidature has been rejected. Issue notice returnable in. You're the only, you're for all, no?
Yes, 1 to 7.
Issue notice returnable in 2 weeks. Mr. Is your name? R. Dubey. Accept notice on behalf of all the respondents. 1 to 8. Who is 1 to 8? Why do you, okay.
9 and 10 I wanted to question.
Okay, each petitioner takes steps for service of notice upon respondents number 9 and 10.
I'm not protesting. But they have to be.
9 and 10. But it is registered forfeit within 3 days. And list the matter on newer date.
Till then they will close the recruitment. That
Huh?
also will be there.
Huh?
20.
20.
But till then they
Let's
will
see,
close.
let's
Till
see.
they will close. If they close it up, my case is gone. So automatically it is there. Otherwise, you will have.
Let us see what happens.
If they close the recruitment, then my case is gone. That's the only case.
Whatever we have done, we have done.
So they have done, but if they close the recruitment, till 28.
Item 45.
This is in DK, that is. This is my attached. If, what is your case? Take a decision on the representation.
I am for the FPSC.
Government, yes. Who's for the government? Who is for the government? Huh? Personal and administrative reforms training and training. Very important.
We paid for conservation of the age.
I know. So let the government decide.
Government decide that.
Yes, you're accepting. Who's? So he's made an application for relaxing the upper age limit. Take a decision. Heard, Mr. D. Gogoi, learned counsel for the petitioner, who submits that the petitioner has submitted an application with the APC. Submits that the petitioner is desirous of participating in the selection process for filling up of which post? For filling up of various posts. In persons to the combined comparative examination to be conducted by the Assam Public Service Commission in persons to the advertisement number 26/22 dated 22/12/22. The next paragraph, the petitioner's counsel submits that in terms of the advertisement, the upper age limit for an OBC candidate is 41 years of age as on 1/1/2022. However, the petitioner, who is an OBC category, who is of the OBC category, is above the age limit. So accordingly, the petitioner has submitted a representation dated 31/12/22 before the respondent number 1.
Is number 33.
When was the last date for submission of the application? 10/2 of this. Okay. Submitted an application. What date is so and so, no? Before the respondent number 1. Respondent number 1. Who is respondent number 1? Respondent number 1. For relaxation of an upper age limit. For relaxation of the upper age limit. So stop. In as much as the date of the date of birth of the petitioner is 30/11/1977. Next paragraph. The petitioner's counsel submits that this petition can be disposed of if a direction is issued to the respondent number 1 to take a decision on the petitioner's representation for relaxing his upper age limit, for relaxing the upper age limit in respect of the petition within a specified time period. So stop. Next, Mr. B. Saikia for respondents number 1 and 2, and Mr. P. Datta for respondent number 3. Submit that there was no objection to the prayer made by the petitioner. Petitioner's counsel. Next paragraph. In view of the consent of the parties, this petition is disposed of with the direction to the respondent number 1 to take a decision on the petitioner's representation dated dated page 31/12/2022 for relaxation of his overage, within a period of on or before, within a period of on or before 9/9/2023. In this regard, the petitioner shall submit a copy of this order to the respondent number 1, along with his representation and date of birth certificate by 6/2020. With petition, the currently disposed.
Item 13.
Matter pertaining to a transfer order. A person who is there on in-charge basis on a regular basis. I was transferred. Person who is there on in-charge basis, he comes up and gets a statement. Hello.
My health is supporting today. I will be taken on Tuesday. One time for I have requested my senior. He knows.
Okay, right. Mr. UK now appears for the applicant. However, Mr. A.R. Buyan, learned counsel for the writ petition, feels that the matter may be listed on 7/2, as he is not feeling well, as he's feeling unwell today. Mr. PP Data, you're there? Mr. PP Data appears for the correspondent number 4. Accordingly, list the matter on 7.
Item 14.
Long time.
I have a position. Anyway, university data you accept this petition, but then will not accept it or it's a kind of we have not. Now we are date of this. I also figure because I don't know but I have come to know they are not terminated. That must be. But still they are working.
So what do you want now?
They will be because I have information. Because this is the 14 that said it is writing in this. All right.
No, what do you want now?
Maybe listed after.
Why?
No, because I have to monitor it. But you pay. No, I don't pay.
You see, you want to be considered in terms of the advertisement of 2012. Now more than 10 years have gone. Then yes, Mr. Khatane, what to do?
They have submitted participant as pending process in 2012. And in that screen, they have been identified as illegal. They were not working also. So they were not accommodated. Who have been found to be working, subsequently government took a decision to accommodate them as a tutor, subject to their qualification. But these petitioners, they were not working well, and they were identified as illegal. So they have not been accommodated. Now they are not in service.
I'm not saying that he is not correct. He's not correct. I'm not saying. Now, because what that if there's something, only there but they're attending for something. They were illegal.
That is not your prayer.
is to be furnished.
But that is not your prayer.
The letters are not a prayer.
Then
They're not
can
a
you
prayer.
can you
This now, we can accepted or not.
not accepted? He just said it. Not accepted. What remains?
Then it's a verbal submission, I have to accept it now. No, in fact, I have a list of.
You bring up the list. You give to them.
Monday, I'll give you the copy of the list. Where it is clearly mentioned. I'll give you.
I have it now to see my almost. But at least I
So when do you want?
On Monday, I'll do it. Or it is, but action is.
Monday is now Friday.
Friday, I'll be not available in the job.
Huh?
Next.
Right, on the prayer made by Mr. C. Barwa, Learned Counsel for the petitioner, who submits that he needs to obtain instructions from his client, list the matter on 16. So Mr. N.J. Katane shall give a list of those, shall give a list made by the state government with regard to those illegal teachers who have not been reappointed by the government to the petitioner's council within a week. List the matter on 16.
Okay, good.
15. Under what act? You want provincialization under what act? Huh? Is it? Please read the writ petition. Is it under the 2011 or 2017 act? Huh? Huh? Then your writ petition is gone because 2011 act has been set aside as unconstitutional. So, huh? I know, but then in the meantime, it has been declared unconstitutional. And once it is declared unconstitutional, it is void ab initio. No action can be taken on the basis of a unconstitutional illegal act. So what you can do is, if you want to withdraw, with liberty to file appropriate, with liberty to file the file appropriate petition before the authority. You can file under 2017 Act, under section 14. Because your prayer cannot be allowed. You are praying for provincialization under the 2011 Act. 2011 Act is one. Okay. All right. Heard, Mr. Heard Mr. J.P. Kachari, Learned Counsel appearing for the petitioner to pray that he may be allowed to withdraw the writ petition, with liberty being granted to the petitioner to approach the appropriate forum by way of an appropriate petition. Mr. S. Thakur appears for respondent number 6, while Mr. N.J. Katane appears for the Elementary Education Department. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn. Mr. Hey Abbas, for point number 6. Liberty being granted to the petitioner to approach the appropriate forum with an appropriate petition. The interim order passed earlier stands the 16. Why?
Because I have to talk with my client
For what?
for after the instruction, whether he has continued or not.
So what is your prayer?
Therefore, regulation of the service. from my 38, 1997, my lord, he was working.
Is there any provision for regularization?
Only one day, my lord.
On the prayer of Miss
I will take.
R.S. Jorin, learned counsel for the petitioner, which is not objected to by Ms. R.D. Bora, leaves the matter after a week.
17.
I will just take this.
Again. In this case, there's asking for more than 2011 Act.
Yes, 2011 Act is set aside by the division bench. Sure. Page 42. But you see, this order is passed in 2015. The 2011 Act was set aside in 2016. That will have to be decided. That will have to consider. Okay, so today's case, this case is a follow-up of this, is it?
Yes.
Oh, it's a follow-up. 15.
And what we are also saying that if there is a new super serving as a English teacher for a certain date, earlier to the respondent number, the private respondent, then say with senior and senior submission and keep permission. So that has been my complete interpreted and the order in the past in favor of the private respondent. Against it as only my 2015 itself. And in spite of direction of the sound twice produced records, more approach has been produced. My other trend is my board and picture being submitted before I submitted the picture. And we of the have the year affinity. That's the issue. That's what
But at the end of the day, you see, the judgment passed was in 2015. Now, in 2016, the 2011 Act has gone. Then what happened? What is the
then my your worship may take a view that the judgment was passed prior to the judgment of this act. The decision has to be taken with one possibility. The other possibility is that now say the new act has come from the
that's what. It has to be now decided as per the new Act.
yes,
Cannot be as per the old Act.
but the issue was the operating copy of the these started in 42.
Yes.
They also will find my love. In view of the married. Paragraph 24.
Yes.
So they have instruction. This was directly responded number 6 and 7 to take joint decision as to whether the petitioner is a lecturer in English, while also being a lecturer of alternative English. If the joint decision of the respondent number 6 and 7 is to be affected the petitioner is a lecturer of alternative English only, in that event the petitioner cannot be considered for coincidence. However, if it is decided that the petitioner is a lecturer in English and alternative English from the date of joining thesis, then the petitioner service will be considered for coincidence.
Honorable was taken the consulting whether the petitioner is an actor of English or English with alternative English in the period of doing so. And this decision has been taken by the as directed by your worship. That decision is at place before. And that is dated by the 22nd of June 2015. Last sentence your worship as such, she has been performing duties as lecturer in English and alternative English in date. Therefore, it is requested that the person of to provincialize the service of this so and so as lecturer in English.
But this is your favor.
Yes, sir. In spite of this, my lord, you do not have to pass and just to 2015.
Yeah.
That is a big deal. Relevant will be 359 for second, third.
So out here, you see, this is a different aspect now. Yes.
So let's kindly come to the other aspects on our book. I learned senior has not tried the right last time,
Yes.
page 52.
Yes.
Consequently, the list of provincial exam may or may not be modified depending upon the joint decision of the taken.
Yes.
Then the process comes to the mile of page 59.
Yes.
Now coming to the WPC number, have a look at page 59.
Yes.
Third page. Now coming to the 3428 filed by Anjali Ahmed. Anjali Ahmed is present. Had na WPC number Anjali Ahmed, the Honorable High Court had ordered that the director, the respondent number 6 and governing body of the college, the principal to take a joint decision as to whether the petitioner is lecturer in English or lecturer alternative English. The Honorable High Court had directed the respondent number 6 and said to take a decision whether the petitioner is a lecturer of English or English with an alternative English with a period of 1 month from the date of receipt of the certificate copy of the order. It is seen the past two concurrence of the subject of English was given in the 96, and the letter was issued Assam Higher Secondary Education Council on 7th 1990. There is no mention of subject alternative English. The governing body of the college has submitted a report. 24 together with the minutes of the meeting of the governing body held 22/6/2000. The date of joining of Anjali Ahmed is shown as 1/2/96 as per particulars submitted by the college. This is not disputed by the Anjali Ahmed. The principal of the college, who is also the president, agreed to the subject English. The services of the lecturer, date of joining has been provincialized. As per rule, only one lecturer is provided against one subject, since against subject of English. The service of lecturer who joined earlier to Anjali Ahmed has been provincialized. As per service of could not be provincialized. As such, Anjali Ahmed has not been found eligible. A service could not be provincialized. Next case. This is my case. It is learned that post of lecturer allotted to the school has been kept. Motidat Khatun, lecturer in economics of the college, although shown as eligible in the list of published website. Her post allotment letter was not given due to filing of the requisition 3420/2015. She was Anjali Ahmed. Now, since the Anjali Ahmed has been adjusted, not eligible for provincial, the post has been allotted to the college be kept pending. The service eligible lecturer will be against allotted post. The service of the Mofida Khatun, I am the lecturer of economics. Lecturer with the date of joining 1/8/6/1997 will be provincial to the said post. And important thing is that, my lord, I have edited my lord. They have tempered the my lord, the managing committee resolution, my lord. If you are not in the final short handwriting he has written down the Anjali Kalita step. Alias is name is Anjali. There has been tempered, and all this disputed question of tax has come. You also kindly go to the my lord.
No, one thing, huh? So we can't decide. Anyway, so you give a copy.
Yes, sir. I will my lord, who has ended the semester country. Today is not available. I said, have the copy. No problem.
Correct.
If the government says that
Yes, Mr. NJ Khatane, what to do? Why don't you file an affidavit? Huh?
thing is that, my lord, that 2011 has been, my lord.
No, that has been set aside. That has been set aside.
No, that's there is a review case has been filed, my lord, that goes to the other provincial state. Anything grievance, there is another act, my lord, this shall go to the, my lord, another.
No, you see, but you see, now you see, the issues basically have been settled. It is now only a question of decision whether she teaches in English with alternative English or alternative English without English. So that issue has also been purportedly settled. Now the only one issue it appears that remains, maybe it's with regard to seniority. So that seniority issue, once that is settled, that can be decided in 2017 Act also may be made applicable. Why not?
My lord,
Waited for 8 years.
Yes.
my lord, as per 2017 act, my lord, it was subject wise, my lord. And he is the second teacher of, my lord, English, my lord. Assuming, my lord, not everything that happened.
In that event, you want to file the review application against.
My lord, I am
Correct.
coming, my lord.
So what's the-
I am coming, my lord, because some document has found, my lord, he has confirmed the document.
No, so you find
Yes, yes,
give
my
a
lord. Let
affidavit.
me, I shall start the document.
All right, Mr. M.K. Chaudhary, Learned Senior Counsel, submits that he has not received a copy of the affidavit in opposition filed by the respondent number 7
Eight.
and respondent number 8. Mr. N.N.B. Chaudhary submits that he will furnish a copy of the affidavit of the respondent number 8 to Mr. M.K. Chaudhary within 3 days. Within 3 days. Mr. N.K. Khataniar, appearing for the Secondary Education Department, is granted 3 weeks time to file affidavit in person. This is a matter of the 3 weeks. Mr. MP Chaudhary appears for respondent number 7.
Being item number 17.
Yes, what is the case? Yes, what? We'll attend the matter. What is there? What? Right. On the prayer of the parties, list the matter after the week. Next.
22.
Transfer the additional level from one to another level.
Yes.
By the utilization of the service level. You already have case 49.
Yes.
There it says, my lord, subject to approval of PLC, the services the following issues are there about to utilize, my lord. They don't use the word transfer, my lord. Word utilize, again, single teacher. Single, you're also single, they are saying single teacher. I will show that this would have two teachers. Correct, my lord. As soon I am concerned with the say number 2, my lord.
Yes.
Say number 2, my lord. Now I will show, my lord, as per 2009 Act, my lord. 2009 Act. Right to life, children,
Just a minute.
yes.
2000.
Right of children, Children and Compulsory Education Act 2009.
Have we got that right to? Have you given a list of books? Huh? Give me education manual. You see, we keep on changing our bench. Huh?
Yes.
What is next?
Yes.
Yes. That's school, my lord. It says, my lord,
Yes.
if the ink from class 1 to class 5, my lord,
Yes.
if the student number is up to 62 teachers will be there, my lord.
Yes.
And if the number of students go beyond 150, then 5 teachers and 1 headmaster. My school, my lord, where I work, my lord, there are 158 students, 2016, my lord. Also, my record is there, my lord. So in my school, there are 6 teachers. But in my school, there are only 3 teachers, including myself, my lord.
Ah,
In the other school where my service has been utilized by, their school has only 19 students.
19.
And 19, and there are only 2 teachers are there. Now my service is going to be utilized in that school.
So we-
only 2 teachers are there.
So there'll be 3 then.
There will be 3 on that. They say it's a single teacher.
Ah,
They say so it's a single teacher. Only 2 teachers are there. I am going to the 3rd teacher. Moreover, I am a head teacher here. I will be an assistant teacher there. Already head teacher is there.
so there is a stay order in this case.
Stay right there.
Yes. Huh?
By this level, the whole thing.
So we'll allow the writ petition. Heard Mr. S.K. Mukhtar, learned counsel for the petition. Also heard Mr. N.J. Khatani, learned counsel for the elementary education department. That is respondent number 120. Mr. P. Saikya appears for part number 4. The petitioner's case is that he is serving as a head teacher in Narayanpur Moktab LP School. However, while order dated 24/6/2016, passed by the respondent number 3, the service of the petitioner has been allowed to be utilized as a teacher, has been allowed to be utilized as a teacher against single teacher school, that is Bargacha Baratola LP School. The petitioner's grievance is that the utilization, is that the impute order dated 24/6/2016, utilizing the service of the petitioner in Bargacha Baratola LP School as a single teacher in the school is nothing but a punitive transfer, in as much as the same is in violation of the schedule made under section 19 and 25 of the Right of Children to Free and Compulsory Education Act, 2009, hereinafter referred to as the 2009. The petitioner's counsel submits that in terms of the schedule to the 2009 Act, there has to be 2 numbers of teachers in respect of schools having up to 60 children. In respect of schools having above 150 children, there needs to be 5 teachers plus 1 head teacher. The petitioner's counsel submits that the petitioner, who is the head teacher in Narayanpur Moktab LPS, is having 150 school students, 58 students, which requires the running of the school by 5 teachers plus 1 head teacher. On the other hand, Bargacha Baratola LPS School has only 19 students and there are 2 teachers already in the said school. He submits that if the petitioner is also sent to is also sent to Bargacha Baratola LP school as a teacher, there would be 3 students, there's 3 teachers for teaching 19 students, which would not be in consonance with the schedule to the 2009 Act. He also submits, he accordingly submits that despite more than 6 years having been passed from the date of filing of the writ petition, the state respondents have not filed any affidavit in this present case, and as such, the writ petition should be allowed. Mr. N.J. Khatanya, the learned counsel for the Elementary Education Department, submits that as he has not received any instructions till date, and as no affidavit in opposition has been filed by the state respondents, he has got no comments to make at this juncture. Next paragraph. I have heard the learned causes for the parties. The averments made by the petitioner's counsel above, and the contents of the writ petition have not been disputed till date. In the case of Naseem Bano versus State of UP and others, reported in 1993, Supply SCC 46, the Apex Court has held that averments are deemed to be admitted, if not controverted. The writ petition was filed on 25/7/2016, and even till today, no affidavit has been filed by the state respondents controverting the averments made by the petition. In that view of the matter, and keeping in view the law laid down by the Apex Court, this court is of the view that there is nothing to controvert the averments made by the petitioner, and as such, the same are deemed to be correct. Accordingly, this court, on considering the above facts, is of the view that the impugned order dated 24/6/2016, utilizing the service of the petitioner against Baragacha Baratola LP School, is arbitrary and unsustainable. Unsustainable, as it is in violation of the schedule to the 2009 system. The same is accordingly set aside. The writ petition is accordingly allowed. 23. Yes.
Yes. Respectfully submit my lord. On 30th of March, when my lord was pleased to take up the matter, allowing pay this form and it is granted by the pay commission of Congress 99. It is for failures and cost is India second. Then my lord, September 2008, in days, it is for the failures Act. For to compensate the citation of the officer, again the pay commission for the concept of NFA, non-functional selector. And 6.
That is not your prayer.
Oh, it's not. So, my only my other submission is that my learning friend produce the policy letter of ACP and ACP, which regards the problem.
No. It's not a question of debarring. A CP and MACP does not debar promotion. It only says that person who has not been promoted, to compensate for his non-promotion, he is given this benefit.
No, the concept is that if there is a stagnation, the pay should
Correct.
be uplifted.
Correct.
In my case is that,
Hmm.
as affirmed by the various judgment of the Supreme Court, and as laid down by the policy of 89 of the GOP, which says that if appointing authority holds a deficit, they have to accept the recommendation of the deficit.
No.
My lord,
Where is the law?
I
No.
have a letter of the GOP 89.
Here's the letter. The Supreme Court judgment says that it doesn't have to accept.
My lord, that
It is only a recommendation.
my humble submission that is the case when there is a difference between the appointing of the recommendation of the DPC and ACC of the secretary, then they can take a different. There, my lord, this is a key where the appointing authority, which where the since the petitioner passed the trade test and been eligible by. So only question is that they have to be given promotion. It is not like that the appointment authority has to take permission from somebody. Even if I have got my, and this is the 89 letter of DOPT says so, and never in the letter is alive, not superseded, has mentioned that the DPC recommendation is not to be activated. Second, second submission by law on the similar line. 2001, the cause of action arose. In Gent of High Court, the petitioner weighed in 2015 after delay of so many years because of what is the past order in favor of the petitioner. Now, advancement of the area has been updated. This is the 2001 14 Gent of High Court order that is with similar case, similar organization, similar plan, no departure. So, my lord, I beg to submit, if my lord permit, I have a copy of Supreme Court order, UPT guideline. These are this order of the Gent of High Court on the subject. I simply did before my lord for my promotion, which was considered unmerited, but they did not implement it against the UPT guidelines. If my lord finds yes, UPT guidelines 89 is quoted by the epic in various judgments, which I am carrying now, then I don't know it. Yes, if it is violated, if the epic says the UPT guidelines 89 is not to be followed. I know there is a calendar here. That calendar year procedure is followed in 1988. Either calendar year or financial year basis. Now this is financial year the following. But one humble submission. Now, based on the DPC,
Yeah, carry on.
if based on the
How much time will you take? Give me.
I finally, my lord's permission, I finally submit some report and only say that 89 UPT guidelines.
How much time will you take?
89 guidelines says that yes, if this is to be paid in each vacancy year, one. If there is no vacancy, certificate to be given, two. If nodal officer to be engaged to monitor the DPC procedure. So, my lord, I have the judgment of the Honorable Supreme Court in the advancement of areas which is a win-win situation for the employer and employee financial benefit as being raised is in the form of ACP, is entirely different. I've never paid before my God to grant me ACP and ACP. I am poor, mentioned working from one hilltop to another hilltop. I get it. Sometimes opportunity to seek legal justice because I am in border roads. I am engaging in Indochina border roads. My God, my unit is located 1,000 kilometers from Guwahati and away from the family. And another last thing, last but not the least, my Lord, it is an army-centric organization.
Huh?
It is an army-centric organization. This border roads, headed by Lieutenant General. In this organization, my Lord, rank, batches, status, privileges are very matter, not during the service, even after retirement. So they have a case facility, they have a all facility, even post-retirement period for extra employment. So I have paid only to grant information, no SCP, MSCP. I don't deny that I have not been granted SCP. Yes, I did grant SCP, past SCP. I did grant second MSCP. I did grant third MSCP, but that was in 2008. And that was not like there. I am not involved for my law on the subject issue. So,
So you admit that you have been given all this. Now
now
you admit. Earlier though you did not admit.
That is with reference to the recommendation of the Regularization as other central government.
We had adjourned this case on 2 occasions, only on that one.
On 27/10, last I remember, I have used document regarding the investigation regarding case number 1, 2, 3, and 4. I have now I have obtained regarding petition number 2, first MSCP 2002, second MSCP 10, and third MSCP 2020. Petition number 3, SCP 1 in 2008, then MSCP come in 2016. This third will be on 2008 to 2026. And petition number 4, first SCP is 2006, second SCP is 2014, third will be a 2024. And
I have a sub document including for many orders. Including order of
Yeah, please don't give me those.
I just give
No, no, you see,
the binding form.
you cannot give me such a thick set of documents just like that.
I just got a spiral writing in the next bit of hearing and give it for my law firm. Because my case is entirely standard different. Other central government employees getting SC and MSc, I am not an exception. I deserve promotion. I allowed my promotion. They did not implement it. And who did not implement is the appointing authority, is empowered people.
Actually, basically,
seeking promotion in
non-existent proposed plus the rules have changed.
And because of the stagnancy, they got into the
More than that, my lord. I'm just giving it example.
So they all financing you here.
Yes, they are having a more pay because my lord, one.
That's what I was thinking. This poor one poor overseer. How come this lawyer can come all the way from North India all the time? I think. Now, okay, so there are 150 of them. Okay.
My lord, I beg to submit.
No, it's
I
okay.
can easily submit. They are getting competitive. What others overshare got 4,200.
No, anyway, you
That is
see,
the only reason, my lord, they did not allow me to put up my next rank. It is a privilege, my lord, in our organization. And foreign organization which work for a nation in the border area, the one promotion in the lifetime before retirement, I deserve. And that is my only prayer. I never prayed for a I never paid for it. I got, but I got 2,000 acres.
Mr. Counsel, how many promotional posts are there for you?
This is only my God, this is the only promotion. I joined as a pioneer, my God. Then I passed state test, but I got maximum, and from maximum this is the.
And that overseer post is
That
gone.
is it. That is the end of it, my lord.
Now what happens if it is gone?
I will become non-commissioned officer. I have a special status in the army safety organization because it is commanded by Recruitment and other army officers. 50-50 ratio is there. So that is why I am getting justice as my lord has rightly pointed out. I am coming all the way, my lord, because it is only a matter of a principle. It's not like that for other disease, which I can give you something. I have taken the matter. And the Gangtok High Court, if my lord have a view on the Gangtok High Court order, my lord will be amazed to see how they have dealt with the various issues, various difficulties faced by the petitioner, and how they are discriminated in not allowing the promotion. So these good finality because they implemented the law. That was the case of 2001, my lord. I went 2017 in Allahabad High Court for agitating the case. Allahabad High Court said, no, it is you stay here, you come to the posted in Guwahati area, come Guwahati. So I came before my lord. In 2019, COVID period, so we are in for 2 years. That's what happened. It's a matter of principle.
Actually, Mr. Counsel, the problem with you is you went to the Sikkim High Court when 2001, correct?
2013.
2013.
Yes, my lord. Call of action 2001. Delayed this much.
And you came to this High Court when?
My lord, I came in 2017 in Allahabad High Court.
Yeah.
Yeah, my lord, I came in 2019.
And when was the post abolished?
My lord,
When was the post abolished?
my lord, they reversed it 2012. So what happened? My lord, 2001 cause of action, they considered it on government, but not necessarily. Yeah, process of law is there.
You see, the post is gone in 2012. You come to this High Court in 2019 for a post which has been extinguished 7 years back. You.
My lord, the other judgment, it stays beyond 10 years because it put it by the Gangtok High Court order. It is, my lord, why I am just saying so, my lord. This, my lord, they hardly get an opportunity
What
because
to
of their posting. And my lord, when I have been selected by VPs with reference to the DOPT guidelines, why I should not get? If the DOPT says no, it is not a fundamental right. Your consideration for promotion is a fundamental right. Yes, I don't have any. Yes, my lord. I show the DOPT guidelines. If my lord finds it that yes, denial of promotion can be made with reference to DOPT guidelines. If my friend says so, I don't have any case. My lord can dismiss me. 89 guidelines, I accept this. Give the only one letter.
The problem is every time you come, you are bringing up a new argument.
No, my lord. I have paid for my promotion, my lord. Having issued.
Yes, well, what to do, Mr. Parashar? He wants to submit those bunch of papers.
No, I give the DOPT guidelines for it. One.
What do you think? I'm Superman that I can just go through that bunch of papers just like that?
I only give the DOPT guidelines, not bunch of papers. Only the 89 DOPT guidelines. If my lord finds that yes, the DOPT guidelines say the promotion is not to be given, then I don't have any case. And DOPT 89 guidelines is followed as a another. The Union of India to their employees filed an affidavit stating that
You think about it. We'll take up your case sometime after some time. Yes, let's do the others. And they are taking up too much time. You said 2 minutes here. We already taken 15 minutes.
so because I have got my wife here I cannot attend the last hearing, and she is under rehabilitation.
Look, actually, the issue is with you. I'm trying to accommodate you by listening to you. That's why I asked you in the beginning, how much time will you take? You said 2 minutes. Now you're not ending your argument also. So either I cut you off and dispose of the case straight away, or you want, you can give that by last chance by way of an affidavit. No more arguments, we will dispose of the case as on. Because I don't want that you to say that you have not been heard properly.
Yes, I you may be allowed to file an affidavit and make statement some kind of this. Because my lord, I cannot tell yes, both the need.
After 6 weeks.
See, after 6 weeks.
Huh?
Question is, because it's under the
Operation.
yes,
Mr. He's asked Learned Counsel for the petition. Is granted 3 weeks time to file affidavit, additional affidavit. With regard to the DOPT guidelines
yes. And Supreme Court judgment on the subject matter.
and Supreme Court judgments on the subject. Yes, sir.
4 weeks time.
4 weeks time. Mr. K. Parashar, Learned CGC, has submitted documents showing that the ACP/MACP scheme has been given to all the petitioners. And the third MACP scheme, the benefit of the third MACP scheme will be given to the respondent number 4.
3 and 4.
3 and 4.
24 and 26.
24 in 2024 and 2026 respectively. This is the matter after 6 weeks. I think I should release this from Parliament. No, don't file any more documents.
No,
You want to file, you file whatever you want to file. Please file it at one go. No more.
One, the last submission, they have stated from my lord that the pay commission has stated not to include overtime. What a life you have made from my lord. They say there is an amendment of recruitment provision to 2008, but what is happening in 2012. So how they are depriving the basic rights of their own.
That was on the basis of a court order according to you.
It is, they have filed a complaint. My lord, in a first hearing question, this thing, shown in the order of notification of 2008. And my lord will be happy to know on the first date of hearing, my lord was supposed to give the order in my favor. Just saying, somehow my lord was in a busy hurry. With reference to Rangia's judgment, then came the Sama, the state of Himachal Pradesh in this 22 judgment. That first day, my lord was, that is my latest.
What to do? The law changed. The law changed in the meantime.
See the applicable condition.
But we are bound by the Supreme Court. What to do?
Has he been an officer? Okay.
What to do? So the Supreme Court judgment came in the meantime. It came, I think, August 22.
So many years.
Yes. Otherwise, YV Rangaya's judgment was there, not on the point.
Then we giving the order. And it is my ill fate. I give the order, my lord, for giving the patient.
24.
Six weeks. 6 weeks. This is after 6 weeks.
Actually, I might have some difficulty in resolution. If you watch it, can come to page 47. For a moment, page 47 of the recommendation. I'm not arguing that approach. Page 47 of the recommendation. That is the order.
There.
Page 47, you know,
Is the judgment.
Page 47 is what Dr. is speaking of. 97 for the 90s. 97 for the 90s.
No, page 47 in my book.
Page 50, you know, page 50. I told that. Page 50.
Page 50, yes.
Yes. So page 51, there are two comments.
Yeah.
Sri Bhupen Gulta and Sri Bhupen Das. I am from Bhupen Das. My friend is from Bhupen Gulta. So this 4 years
Mr. N.J. Khatania appearing for the secondary education department, elementary education. Secondary education is granted. For which time to file affidavit in position. This is a matter of course. 29. Affidavit is necessary. Is affidavit necessary?
Here, he was asked to appear before the verification committee by the
Yes.
2 times.
Yes.
He didn't turn up. This is my instruction. In the morning, I have this is my instruction.
When we, on which date? You file the affidavit there?
Yeah, in the affidavit. In the morning, I have
Right. Right, Mr. D. Bhuyan, learned counsel for the petitioner. Mr. N.J. Khatania, learned counsel for the elementary education department submits that the petitioner did not appear for the interview.
for verification of document.
For verification of documents. For verification of documents, and as such, she was not selected for the post of Hindi teacher. Mr. N.J. Khatania shall submit an affidavit with regard to instructions received by him within 2 weeks. 2 weeks. This is the matter of 2 weeks.
Obligation.
Party.
By the department dependency of this case, and here, as per the new notification which is coming to existence, as per this, we are qualified for so our first year has been mitigated by the features of this notification method, and the second year, we are the gradation is including our.
What is your first prayer?
First year, we select the earlier notification to regulation promotion for the post of advancement and regulation. That has been modified by the
So your first prayer was to modify clause 2 of the 2/3/2010.
Yes.
So now
It is come.
this has been done. Then second
Second, we
thing,
have to prepare the gradation list as per the new.
which notification? This notification. So the entire it has become infractional because of
In
this.
any case, we will prepare the new petition as per the phase notification.
Earlier, but in the earlier gradation list, we are not included because at that point of time, we could not complete 10 years of service. On 31st of December, we have completed 10 years of service. Now we are eligible.
They are eligible, obviously, then they will get.
Heard Mr. B. Protesta, learned counsel for the petitioners who submits that in view of the notification number AEE full stop 509/2019/45 dated 8/3/2022 issued by the Special Commissioner, Elementary Education Department, the present writ petition has become infractious. Full stop. Correct. Nah. The prayer of the petitioner for modification of clause 2 of the impugned notification dated 2/3/2010 has been taken care of. He, however, submits that in view of the notification dated 8/3/2022, but you have not asked for setting aside. Where? Where is that 2/3/2010? Page 41. No. Where is the annexure 2/3/2010? But where is the gradation list? Not made. What gradation list? That they will make. So why should we? Huh? There is no prayer. Where is the prayer? Full stop. So here, full stop. Accordingly, the respondents are directed to. Accordingly, the respondents. Accordingly, whenever gradation list of assistant teachers of upper primary school for the purpose of promotion to the post of headmaster is made, the same shall be made in consonance with the notification dated 8/3/22. If as the petitioners have completed 10 years of service as upper primary school teachers on 31st December 22, the names of the petitioners should also be included in the gradation list to be made in terms of the notification dated 8/3/2020. The petitions accordingly disposed. The notification dated 8/3/2022 is made a part of the record and marked as an extra. This is for promotion to headmaster. Upper primary, only upper primary. Yes, sir. Upper primary, no?
Yes.
So that even I remember. Item? Yes, what about it? Okay, Mr. M. Khan, non-counsel for the petitioner is granted 1 week's time, 1 week time to file affidavit in reply to the affidavit filed by the respondent number 4.
Private respondent.
This is the matter after interim order to continue till the next day.
24.
No one appears for the parties. Accordingly, let this matter after a week.
35.
Complied. Okay. Mr. P. PH for what? H for horse. PH for what? Learned counsel for the petitioner submits that the order dated 30/4/2019. Correct? 30/4/2019 passed in WPC 145/2018 has been complied with. Accordingly, the contempt petition stands closed.
36.
What to do? Notice was issued on 4/11/2020. Fresh steps. Now it will be different. I am quite sure the officers must have changed also. Right. Mr. R.S. Chaudhary Chauhan appeals for the petitioner. Full stop. Office note dated 22/7/22 states that notice was issued to the respondents number 2, 4, and 5 by a registered post with AD on 4/11/2020. Letter dated 14/12/2020 was received from the respondent number 5. Addressed to the Director of Secondary Education Assam. However, there was no return of AD card or unserved notice from the respondents number 2 and 4. The petitioner shall clarify whether the respondents number 2, 4, and 5 are still holding the post, as reflected in the post title by the next date. This is the matter after 2 weeks. Now, before this is the matter after 2 weeks, in the event new incumbents are posted, the petitioner shall file. The petitioner may file an application for impleement of the new incumbents. This is the matter.
37.
How many respondents are here? Right. Then what to do? Huh? Okay, Mr. Who is the new incumbent? Any idea? Huh? Just a minute. Mr. NK Nyog. Nyog, Senate Council for the petitioner submits that the respondent number one has been transferred or retired. What? Has retired. And in his place, one Dr. Bijay B. B-A B-I J O Y-A. Dr. Bijoy Chowdhury. Choudhury. Commissioner Secretary to the government. No, Bijoy Chowdhury also retired. Yes. She retired on 31st January. I think she retired. Because I remember Mr. D.K. Das, this case. Anyway, we'll leave this aside for some time. Next.
38.
Now, what to do? Who is appearing for the other side? No, can we dispose it of now? Affidavit not required. Then can we dispose of section 14? Right.
My grievance is that although my case has been recommended by the district superior committee, but the state level superior committee has dropped out my name. I think my place was a non-recommended teacher. He's submitted to provincial, but because it's page 18.
No, it's okay. Right. Since it is going to be decided under section 14, just all right. Heard Mr. A. Deka, learned counsel for the petitioner. Also heard Mr. P. Talukdar for respondent number
1, 2, 3, 4, 6, 6.
Mr. P. Saikia,
Number 6. 1 to 5.
1 to 5, and Mr. P. Saikia for respondent number 6. I think it's here, no? Full stop. Then you take this this paragraph at order dated last order 31.3. Take this paragraph. Then you take this paragraph. Okay. Next. The next paragraph. The petitioner's counsel thus submits that the petitioner should be that the petitioner's service should be provincialized under section and under the 2017 Act. The next paragraph. The counsel for the response he however submits that in view of section 14 of the 2017 Act, the petitioner may be allowed to withdraw the writ petition with liberty to file an appropriate petition under section 14 of the 2017 Act before the Secretary of the Elementary Education Department. Next paragraph. The counsel for the respondent submit that they do not have any objection to the prayer made by the petitioner's counsel. Correct. Yes, sir. In view of the consent of the parties, this petition is disposed of with a direction, with liberty being given to the petition to file a statutory appeal under section 14 of the 2017 Act within a period of 10 days from today. So, stop. In the event the petitioner files the statutory appeal, the appellate authority shall dispose of the said representation said appeal within said appeal after giving an opportunity of hearing to the concerned parties. The writ petition is accordingly disposed. Huh? Okay, the entire no, should be disposed of, I said. No? It should be disposed of within a period of 2 months from the date of receipt of a certified copy of this. Till a decision is taken by the appellate authority, just give me that. The effect of provincialization shall not be given to the respondent number 6.
27.
Yes.
Now say from the secretary to the limited.
Okay, so she is still okay. Doctor, so what is it?
Mr. M.K. Nagani counsel for the petitioner submits that the respondent number 1 has retired and in his place one Dr. Bijoy Chaudhary, Commissioner.
Commissioner or secretary? Not commissioner, secretary. Has been one with Dr. Bijoy Chaudhary has been posted as secretary to the government of Assam Education Elementary Department. Dispur, Guwahati-6. He accordingly feels that Dr. Bijoy Chaudhary should be implemented as respondent number 2. Next, anyone for the other side? No one. Next, the prayer of the petitioner's counsel is allowed. No, Dr. Bijoy Chaudhary, secretary to the government of Assam, Education Elementary Department, Dispur, Guwahati-6 is implemented as respondent number 2. Registry to make necessary correction to the cross title. Issue notice to the respondent number 2. Petitioner will take steps for service of notice upon the respondent number 2 by registered court proceeding within 7 days. Within the matter after 4 weeks.
39. Salary and promotion of the examiner of the petition. We carried from 29 to 16. On the other hand, we have both. The last program was
On the last date, it has been stated. Mr. S. Sharma, learned counsel representing the petitioner, shall furnish a copy of the writ petition to the learned standing counsel accountant general within 2 days from today. Has it been given?
they are given. They are acknowledged.
Who is appearing for the other side?
Any responsible for the they have
for their own standing notes.
Huh?
They have their own standing notes. Empowerment letter.
Admission hearing without any, what is their stand?
The matter is for pension matter.
Non-payment of pension.
Yes. Pension and salary. If I am otherwise eligible to get pension, comment may accept it. But so far my salary part is concerned, not a single penny was taken. And you are regularized, you have undergone training, there was specific order.
When was he regularized?
What was it?
When was he regularized?
Yes. Yes. 106. Connection 10.
Right, heard Mr. A.K. Purkasa, learned counsel for the petition, who submits that the petitioner's pension and arrear salary has not been paid. Yes, sir. Mr. V. Tarukdar, B. Tarukdar appears for the respondent number. Appears for the respondents number 120. No one appears for the respondents number 3 and 4. 4 and 5. The respondent shall file their affidavit within 3 weeks. This is the matter.
Item 40. This matter also acted for sometime to 5 hours.
Mr. B. Tarukdar, learned counsel for the Elementary Education Department is granted 3 weeks time to file affidavit. Or the same thing.
No, it is not saying.
Okay. This is the matter. Give a date.
When? 46.
Although I have received the instruction from the department manager. This is the instruction from the department. And as per department rule, the section 422, the Assam Education of Services of Teachers and Reorganization of Education Institutions Act 2017 as amended 2018. The teacher and tutors must have rendered at least 6 years of continuous service as of 1/1/2017 from the date of joining in the concerned educational institution, which must be on 31/12/2010 or prior to that. On that date. Since the petitioner service was converted to assistant teacher on 4/1/2013, hence the eligibility criteria rendering at least 6 years of continuous service as assistant teacher on 1/1/2017 does not fit. Second last bottom number. And thereafter, on my above facts and circumstances, the matter of provincialization of the services of the in respect of Tulunga Lahiri as assistant teacher third post of Pamua Pothar high school could not be considered due to non-fulfillment of the condition laid down under section 423 of Assam Education Provincialization of the Services Teachers and Reorganization Act 2017 as amended. Earlier he was a language teacher. Thereafter he converted to a
Yes, what to do? Huh? What? I can't hear you properly. This is enough, more than enough. Now you're going to challenge this document. Give him a copy. Right, Mr. B. Ramchari, learned counsel for the petitioner is present. Mr. U. Sharma, learned counsel for the respondents number. No, you have given the entire batch. Isn't it? Okay. Submits that Mr. U. Sharma, learned counsel for the respondents number 1 and 3, has submitted letter dated 1/2/2023, issued by the Director of Secondary Education, Assam, along with other documents, to show that the petitioner's prayer for provincialization of his service could not be acceded to in view of non-fulfillment of the condition laid down under section 4 bracket 2 bracket Roman 3 small of the Assam Education bracket Provincialization of Services of Teachers and Reorganization of Educational Institutions bracket close Act, 2017, as amended in 2008. Anyway, you go through this and we'll see, we'll list it some other day. Okay. Mr. B. Ramchari has been given a copy of the letter and other documents to enable him to go through the same. List the matter after 2 weeks. The letter dated 1/2/2023, issued by the Director of Secondary Education, Assam, is made a part of the record and marked as Annexure X. You just see, I think probably you'll have to challenge that by closing this. Otherwise, think about it.